Behind every crime lies a story waiting to be uncovered, from chilling mysteries to untold truth. This is where the darkness comes to light.
Green buzz lights up the air, faces tense as stories tear, truth and lies like a tango dance. Justice here takes no chance. Gavel strikes, hearts beat fast. Witness takes and shadows cast. Whispers loud like wildfire spread. In this game, none's ahead.
Hello, good morning, everybody. It's Friday. We've made it to the end of the weekend. Good morning, Lois. Good morning, Becky. Hi. Hi, Pickles. Hi, everybody. Good morning. Paula, good morning. Happy Friday. It's the almost the weekend. We are I actually forgot exactly, like, we are gonna do some court hopping today. But there is a hearing that has actually just started, I think. um it's supposed to start at 9 a.m. They just went live. Good morning, Denise. Hello, good morning. Sorry about it. There's gonna be no camera day today. I'm not doing 100%. But it's just one of those hard days again. So I haven't had one in a while, so I guess I was overdue for one. So but it'll be fine. It's Friday. It's gonna be a good day. We're hanging out together. We're gonna be doing some court hopping today. There are some hearings happening, so we're gonna be watching those, and we're gonna have some fun together. So yeah. This first one actually is Darnell. I'm always saying his name wrong for some reason. Um, his name is Darnell Jones. Is returning to court. It's a pre-trial hearing for the murder of Kane Money Latig. Is his daughter. So basically, his story is due back in is from Lucas County, Ohio, for it's a death penalty case involving the unaliving of the 13-year-old daughter of Kay Manny Latig. So recently, the prosecution of the Lucas County has filed a document listing 234 pieces of evidence in the case, including some body camera footage, ring doorbell, interviews with family and witnesses, video from multiple homes and public buildings in the area where everything happened. So he's facing charges of aggravating and aliving, kidnapping, CSAM, abusive corpse, and many, many more. He has pled not guilty. So yeah, that is the case. That it doesn't sound great case, but yeah. Good morning, Britta. Hi, it's so good to see you, my friend. Hello. I'm waving behind the camera. It's going to be a no camera day today, but yeah. So the hearing. Oh, I forgot to turn off the thing. Hang on. I forgot to turn off that reaction thing. That is annoying there. So yeah. Hi, Zio. Good morning, my friend. Yeah, hi. You awake already? That's early. Good morning, my friend. Hi. I'm again waving behind the camera that you guys cannot see. But anyway, so we'll start doing this because the hearing already kind of started, so we are a little bit behind. Oh, Pickles, thank you very much for supporting for 3 months, girl. You are amazing. Thank you so much. I might cry today, I might not cry. But nothing is new. If I did not cry, it wouldn't be me doing the live stream. Well, you guys would probably be nothing. It would be me. But thank you very much, Pickles, and thank you everyone for the support and being here. Sorry, I did say it was a hard day, so tears might come. Anyway, let's play the hearing because you guys are more interested in the hearing than actually hearing me talk. So yeah. Lois. Hey, you hit Josh. That is awesome. Thank you. I am gonna cry, but that doesn't matter. Thank you very much, Lois. It's so good to see you. Thank you very much for that. Appreciate you. Yeah, never mind. I knew I was gonna cry today. Waiting here. We can just go until where they started, because I don't know when they actually start. Hey, you, CEO.
All rise.
You girl, thank you, CEO. I appreciate you. You're gonna make me cry too, girl. But thank you very much. I appreciate you. And welcome back too.
Okay, everybody, please be seated. Okay. CR 250548, State of Ohio versus Darnell Jones. Good morning, everybody. Mr. Baronis, Mr. Jones, Mr. Lucas, you're here. On the defense side, Ms. Jack Wilson, and Ms. Cook on the state side. I'll note for the record that we have some friends of the media here today. I see Vera in the back is the victim's representative here this morning.
No, she already promised she will not be coming today.
She knew about today, but
Yes.
is unable to be here.
Correct.
Okay, I understand. And we have some other folks in the gallery with lots of empty seats. I believe we're also broadcasting these proceedings to the two TV monitors on the first floor in case there were going to be any overflow problems. That's obviously not the problem, or not the case rather, this morning. We have ample seating room in the full. I'll note that Mr. Jones is dressed out in civilian clothes. So here we are. I filed a preliminary case management order with an agenda for today's pre-trial hearing. And first of all, has council had a chance to look at that?
Yes, Your Honor.
We have. Okay.
Yes, Your Honor.
I'd like to go through my agenda items, and of course, we'll have some other things to talk about as well. So I do see, Mr. Lucas, where you filed this morning a request for expert assistance and for an ex parte hearing under Rule 42E, correct?
That is correct.
Okay. Perhaps when we finish these items during open court, unless there's objection from the state, we can go to chambers on the record and discuss whatever it is you want to discuss with regarding ours.
We're prepared to do that. Yeah, that would be great.
I believe you had also already filed one motion in the seal.
We did.
For an expert,
Correct.
without divulging
Identity.
the nature of that expert's expertise and the kind of work the expert will be doing. I did also file an order regarding expert witnesses, regarding billing, keeping the court updated on what they're doing, how much they're costing, making sure that they're available for an eventual trial date, et cetera. Lucas?
Thank you. The experts that we are going to be requesting funding for have all been given a copy of the court's expert witness order, have indicated to me that they are fine with the compliance that the court requests, and that they are available for the scheduled trial. So per the court's order, we made those inquiries before we came to ask for funding.
Thank you, Mr. Lucas. The state has yet to identify any experts, as I'm understanding things.
Correct.
When Mr. Jones was here last time, and Mr. Jones, again, good morning to you. I asked about some mental health concerns. Perhaps that's a matter you'd like to discuss in chambers, or part of the matter that you'd like to discuss in chambers later. But as I recall, Mr. Jones noted some of his claimed mental health issues. Will the defense be investigating those for possible resolution by the court?
Oh, absolutely. We've started, actually. So, without revealing a whole lot here in open court, records have been requested, are being requested. The appropriate exploration is underway, for sure.
Oftentimes there's a request when evaluations are requested by an attorney for copies of prior case dockets involving other offenses, precepts investigations from alleged other offenses, etc. and those are usually collected by the court for submission to whoever needs to look.
Yeah, some of that material has actually already been disclosed in the state's initial discovery disclosure. I don't know that that's all of it, but it's certainly a good start. So if we need court assistance in collecting some of those items, we would approach the court for that. But we do have a bit of a start on that issue as well.
I'll ask defense counsel in your meetings with your client. Obviously, Mr. Jones is present today in a wheelchair again, which kind of indicates to the court some physical handicap or injury. Can you advise the court in terms of what kind of treatment, the sufficiency of whatever treatment he needs for both his medical needs, his physical needs, psychiatric, psychological needs, etc.?
Yes. So again, without airing out a lot of protected information, there have been a couple of issues that have been raised. The jail has been very accommodating. I spent about 45 minutes with the administrator yesterday, sharing some of the issues. Not only was the jail administrator present, but the head of the mental health medical wing was also present. And I think there's already been some improvement, I should say. And I think with some cooperation and effective communication, I think the remaining issues that have been raised can be addressed without court intervention.
Mr. Jones, how are you feeling today?
Nerves hurt.
I'm sorry?
The nerves in my leg hurt.
Your leg hurts?
His nerves and his leg hurt.
His nerve and your leg hurt. And I understand you're receiving some kind of medical treatment for the leg. I know you're nervous. I can understand that, certainly in the nature of this case. But otherwise, are you able to understand what's being talked about today?
Yes.
I asked you before if you had any hearing problems or any vision problems, and I think you told me that sometimes you use reading glasses, right?
Yes, sir.
Right. There's going to be a lot of documents that your attorneys are going to have for you to look at. Are you able to read them when you're over there at the jail?
Most of the time I've had them read them to me.
Okay. If there's any need, Mr. Lucas or Ms. Ronas, for reading glasses or anything else to assist Mr. Jones and aiding you as counsel, I'm happy to intervene if I need to, but it sounds like you've made such great progress with our friends at the Lucas County Jail that probably.
I think it'll be okay. If he wants some glasses, I think we can get him some glasses without any problem.
Could we take a look at council, the preliminary scheduling order? Yes, for the record, was filed on May 14th, journalized the same day, I believe. And on that preliminary scheduling order, again, it was just a suggested dates, nothing hard and fast. But since I sort of pulled those dates out for purposes of scheduling, I'd like to get your thoughts. Maybe I'll start with look back over with you. The feasibility of adhering to a schedule like this.
Judge, we did have a meeting with the attorneys yesterday to somewhat discuss the court's preliminary scheduling. The first, of course, date that the state needed to address with the court is the next pretrial date set for June 27th. Ms. Cook and I are both scheduled together in another murder trial in front of Judge Marks that will be proceeding that day. So unfortunately, I know the court wants to keep these on track with monthly pretrials. However, the next available Friday for the state after June 27th would be July 18th. I'm only mentioning that date now before the court because it would mean there wouldn't be a pretrial in June. And I know in discussing time waivers, which was another issue with the court, I mentioned that date to Mr. Lucas. So that was just the first date the state wanted to put before the court. The other dates, the state will work diligently to adhere to those. Of course, we're respectful of Mr. Lucas and Mrs. Baronis' schedule relative to all these dates as well.
Lucas, Ms. Baronis?
So as the state indicated, we did, per the court's suggestion, get together and talk about these dates. I guess the defense position is this, the way that the various events are laid out chronologically is fine with us. The dates seem a little bit problematic for two reasons. Number one, while we certainly appreciate the vote of confidence by the court, our ability to write the constitutional motion by June 4th is slender at best. It's a long motion. There have been some changes in the case law. Quite candidly, neither Ms. Baronis nor I have written one in a couple of years, and it's going to take a little bit more time than that. What I think, I don't want to speak out of turn, and the state can correct me if I'm wrong, but it kind of segues into the next agenda item, which is the discovery. The state has been very responsive. We have a lot of discovery. And when we were meeting with the state yesterday afternoon, on the desk was more discovery. And then it was represented to me that there was another batch behind that one. And so what we had sort of concluded is that, to set dates that the court really wants the parties to adhere to would be a bit unrealistic until we've worked through some of this discovery. As of today, I approximated 250 gigabytes in the disclosure that included 1,500 pages of documents. Nobody's sitting on their hands here, but it's a lot of material. So as far as the way the court has things structured for disclosure, I don't know about the state, but we don't have an issue with that as far as who discloses what when. The dates might be problematic just because of what we anticipate to be the amount of discovery. And that after we get through the discovery, or at least a good chunk of it, then we would probably be in a position to commit to some dates. That's kind of the defense take on the schedule.
So I'll ask the state then regarding discovery. Do you anticipate yet more production for the defense? Do you pretty much have it all now for Mr. Klukas and Mr. Ronis to go over with Mr. Jones? Where are you?
I would say we have sent out about half of what we're currently in receipt of and are in the process of reviewing it, uploading it, redacting it, and putting it out in discovery. Mr. Klukas was correct. I think we're at about 1,500 pages that have gone out, over 200 videos, which are very, very cumbersome to watch and to go through. I believe as far as our evidentiary experts, we have at least one, if not two of those reports ready to go out into discovery. And we are in the process of working on a additional expert report relative to cell phone evidence that we just received the official records for and are beginning that process as well.
Do you have any sort of a timeline whereby you think you'll be in a position to turn over to the defense essentially everything that you're obligated to turn over to them?
We are working diligently toward that August 29th date that the court has set. So as the court is aware, as cases continue throughout the court process, we have small disclosures that are sent out, but I'm confident that certainly, if not before that date, we will have the bulk of discovery into Mr. Klukas and Ms. Baronis' hands.
Thank you, counsel. Let's start, if we can, then with the resetting of the June 27th. Did I suggest June 20th?
No. we have a trip planned that weekend.
Did I suggest late afternoon, I should say 3 o'clock, as we did with the arraignment, Wednesday, July 2nd?
Oh, I'm sorry, that's fine with me. Is that good with you? That's fine with me.
Judge, I will be available for that date, Ms. Cook. Maybe not.
I have a trial scheduled in Judge English's courtroom. It's possible it could be done by that date, but I'm sure Mr. Ted Wilson could cover for my presence.
June 27th, 2025 at 9 a.m., resetting it to 3 p.m. Wednesday, June 2nd, or July 2nd. You mentioned, Mr. Klukas, regarding at least the constitutional motions and that rather quick deadline to file those motions. As I mentioned before, when we were together at arraignment, if you believe that you need more attorneys, certainly the Ohio Public Defender is more than willing to have me appoint additional attorney assistance if you thought you needed it for this case for any purpose, essentially. But would that be of any help to you?
We are exploring that option. Yes, that probably would be helpful. We've actually started talking about that. We're probably not quite to the point where we're ready to make the request, but it is definitely being considered. However, I don't know that the third attorney would be necessarily helpful on the constitutional motion, but it might free up some time. So I will tell the court, it's my habit in these kind of cases to get that motion filed much sooner rather than later. So even though I indicated that June 4th may not be doable, we're going to get to the court as soon as we can. For me, that's just the way that I've normally gone about this. Just, we want to get it in. So
maybe I will do this then, since you've already met and conferred regarding potential dates in this preliminary scheduling order. Could I ask you to get together and actually put to paper dates and deadlines that work on your end?
Sure.
And as long as they work on my end, we're in agreement. If they're not, then we'll have to have a hearing and discuss it. Let me go to the far end of this case, which is trial. I had suggested a trial commencement date of April 20th of next year, which would give you more than a year essentially from kind of arraignment, et cetera, to get this case to trial. Do you see any problem with that?
I can't say that I see a problem with it today. But I mean, there's so much time between today and then, and so much that actually both parties don't know yet, that I would hate to commit to it. I think as a target, yeah, I think as a target, it's fine. Generally the cases of this nature that both Ms. Baronis and I have done in the past tend to go 12, 15, 18 months, somewhere in that neighborhood. The initial date that the court set is within that range. But I just don't know enough about the case to say, yes, we'll be good to go by April 20th. So
my original thought was 9 months. You're saying that would have been too.
I would have stood right up here and said, not doable. So as a target, and I don't know, it may work out. I just don't know enough right now to commit.
Well, again, if you'll be conferred and then submit to the court jointly an agreed upon, if you will, preliminary schedule. I get it. Delays happen, issues come up, hearings have to be held and scheduled sort of on the fly. Understandable, especially in a case like this. Okay. Anything else that the council wanted to bring to the court's attention regarding the scheduling order?
Not from us, Judge.
Now from the state.
As you mentioned, Mr. Klukas, that would segue into discovery, and I think we've had a decent discussion on that so far. Usually in homicide cases, at least from my perspective, what seems to take a while are camera, whether it's dash cam, ring cam, body worn cam, all those different cameras, and it sounds like there's going to be a fair amount of that in this case. So we'll talk about that. Can you give me an indication on where you are with the coroner's report, as well as any toxicology therein?
I believe that will go out to Mr. Kukas and Ms. Baronis on Monday.
Oh, great.
Tuesday.
911?
That will also go out on Tuesday.
Oh, good. So it's soon.
We have it.
Okay. Any supplemental police reports?
The bulk of those will go out Monday and later on next week. And I believe we're just waiting 2 additional supplemental reports.
And I believe the defense filed a supplemental discovery request. Was there anything in there that is going to be problematic for the state to respond to?
No, it's not problematic in any way. There were additional items that we requested the investigating agency to submit to BCI. Once we have those results, I will put in an official request to that agency for the full records to turn over to defense. Generally, we wait until all the testing is completed before we ask for those materials.
Talked about a moment ago, the time waiver that Mr. Jones executed with council takes us to June 27th, if I recall correctly.
I think that was the date we put in, yes.
And we just reset our June 27th pretrial to Wednesday, July 2nd. Is it,
Did we waive till today, or did we waive to the 27th?
you waived until June 27th?
We did, okay, thanks. Mr. Jones and Ms. Baronis and I discussed this. We are willing to sign another time waiver to the July 2nd date. After July 2nd, it's the defense position that there are going to be a large number of tolling events. Eliminating the necessity of a time waiver, at least from the defense perspective. But we do need the time from today till July 2nd, and we talked about that with Mr. Jones. So we are willing to execute another time waiver to the next pretrial.
Was there a request for a bill of particulars?
There has not been a request for a bill of particulars made yet. I don't know, but at least Ms. Baronis and I talked about that. Our collective habit is we need to look at the discovery first before we can figure out what may require particularization. So, and because of the nature of the case, there probably will be one. I just don't want to make it a shotgun boilerplate. I don't find that useful. So once we get through the discovery and we identify areas that may require particularization, then we would probably request one.
And has provided for the court here a waiver of time limitation that would take us to the next pretrial of July 2nd, 2025. Councilman Approach.
Thank you.
Mr. Jones, you heard me discuss with your attorney the waiver of time. As we talked about when you were here a couple weeks ago, we have two rights to speedy trial. One is contained in the revised code, and one is a constitutional right to be tried within a reasonable amount of time, essentially. The document that I just handed to Mr. Lucas, if you agree with it, would waive all of those rights to a speedy trial to our next pretrial, which will now be Wednesday, July 2nd. I'm going to ask you to take a moment to review that with the council. If it needs to be your approval, please sign where indicated, and if you have any questions, please let me know. Mr. Lucas, I'll note that the time waiver has been signed by Mr. Jones and by counsel. Mr. Jones, You reviewed this form with your attorneys. Do you have any questions about it?
No, sir.
You understand that you're waiving your speedy trial rights until at least July 2nd, 2025.
Yes, sir.
We're signing the entry and it will be filed record with this. Leah, I know you haven't gotten all the discovery yet. Perhaps the state might know or the defense might know anticipated length of at least the trial phase. How about
Okay,
adding
so-
to that the length of it, anticipated what?
We did discuss that yesterday. In past cases, I can at least address the length of voir dire. I believe, well, I know the defense will be submitting a questionnaire. That does tend to streamline things a bit. The defense will certainly be asking for individual sequestered voir dire also. So in the past, what it has taken to seat a jury in this type of case is generally a week. Sometimes it spills over to a couple of days into the next week. So between 5 to 7 working days for voir dire. I admit that I'm in a poor position to predict the length of at least of the trial phase of the trial. We just don't have enough discovery yet. It appears to me that it's going to take a bit. But that's about the best I can do right now.
I would concur with that assessment, Judge.
Mr. Lucas, when we were here last time, you asked for the opportunity to revisit the issue of bail. Do you wish to do that today?
No, we're going to continue to waive our any right to present anything today with the understanding, again, and I talked to the state about this yesterday, that if we do have terms and conditions to present to the court, we would give the court some advance notice and the state some advance notice, and we would put that in writing. We're not in a position to do that today.
Mr. Jones, let me talk to you for a minute. First of all, how you doing? Remember that when you were here last time, you and I went over a lot of your constitutional rights.
Yes, sir.
Okay. You have the right to counsel, you have 2 attorneys, you may even have more, depending on if Mr. Lucas and Mr. Ronas need some more help, okay? You're presumed to be not guilty of the charges and specifications, right? Understand that? You have a right to a trial by jury, you have a right to a trial, if you don't like that, to a 3-judge panel. You understand that?
Yes.
Okay. Remember those other rights we talked about before? I'm not going to go through them all again and just talk to you about the nature of how the trial's in 2 phases. We talked about that at length. You've now had some time to think about what I told you about and what you told me that you understood, and you've had time to meet with your attorneys between then and now. Do you have any questions for me about any of your rights, any of the procedure on how this trial is going to go forward?
No, sir.
Okay, if at any time you do, please let your attorneys know. In addition to being the defendant in the case, you're also, we want you to participate, be able to participate in helping them present a defense to this case. Do you understand that?
Yes, sir.
Okay, so if anything gets in the way of that, I want to know, all right?
Yes, sir.
Okay. Ms. Liptak Wilson, anything else for today's purposes from the state?
No.
Mr. Lucas, anything else from the defense?
For the open court proceeding, no.
Yes.
Yeah.
Okay. All right. Does the state have any objection to the in-chambers ex parte hearing on motions that have been filed under seal by the defense?
We have no objection.
All right. Pursuant to Criminal Rule 42E, I'll ask that our court reporter and defense counsel and the defendant come to the chambers, and we will have that discussion on the record, but the record will be sealed of our discussion in chambers. We will then come back out to the courtroom and place on the record maybe a generality of what has been talked about there, and then we'll be finished for the day. Okay?
Thanks, Judge.
All rise.
Thank you.
I really don't know.
All right, so that is it on that hearing. So it was mostly setting some dates, going over the turning over of that much evidence that they had the 234 pieces of evidence, and then just I don't know why he's in a wheelchair, Denise. I haven't figured that part out of why he's in a wheelchair. Um, I don't know. He was in a wheelchair in last hearing, in the first hearing that he had about in this case, and now he's there. So yeah, I don't know. I don't know. Sorry. Or don't talk to me about hot flashes and all of that. I'm having a hot flashes because I have a hot flashes because I'm weird. Oh, did he? Oh wow. Yeah, probably that was it. This was in Ohio, Lucas County. Um so this was in Lucas County, Ohio. um so I think we attend to Toledo, Ohio. Yeah, that's which is interesting. Yeah. um Oh no! Oh, sorry, Zio. You did not miss anything. He was denied bond again. So well, not denied. The defense did not ask for bond. So there was not much you missed. That they were talking about turning over the evidence. They said some preliminary hearings for July, and then they went over lightly over the 234 pieces of evidence that the defense that the prosecution entered, and then they go on to an ex parte meeting without the defendant but with all the attorneys, without the cameras, and that's where the hearing finished. So yeah. So I mean, now that was one of the hearings I want to watch today. I don't know what else is going to come up today, but what we could do, we like some courts are on, but they're doing tenant stuff. I'm not really into tenant stuff. uh I'm waiting for either Judge Fletcher to come on, but it might be a bit, about 25 minutes until they come on. Or something happened in Colorado. I don't know why. Is it a holiday in Colorado? Because literally nothing in the Colorado system is working for me. um yeah, victim was his daughter. Yeah, 13-year-old. That was the victim, his daughter, which absolutely, um you know. Oh, really, William? Oh, wow. But I don't think this one is faking it, depending on that injury that he suffered during the. Yeah. Oh, is it only half seven in Colorado? Oh, oops. My bad. So, oh, actually, oh, wait, we have a felony docket. I don't know which judge is this one. I've never seen her before. She's not talking right now. Where does she say is where she's from? I have absolutely no clue. If I'm gonna put the name in the chat, if you wanna search on where the judge is, we probably can see from where the judge is, but she's not even talking right now. So, um, this is a felony court, which is good because we don't want any tenant stuff. Sorry, but tenant stuff it's not very captivating. So, yeah, everything is half open, so it's gonna be a struggle bus. But I want to see if Judge Fletcher is gonna come, and we might do a little bit of court hopping, watch Judge Fletcher for maybe a couple of hours, and then probably I'm gonna call it a day there. But I did want to hang out with you guys. I wanted a bit of a distraction. Um so yeah, yeah. So there's a bit of a distraction because it's been one of those hard days, but it will get better. Garden Bot is finishing on work soon, hopefully, and oh, is in Michigan. All right, cool. Right. Hopefully she will start doing something. Meanwhile, I can go fishing for something else. I can keep refreshing the YouTube and see what's going on, because not even Diddy trial is going on. We cannot even see that. There is a press conference of the Grady Judd, that is sheriff in Florida, and he's doing a press conference. It's probably about, like, because he always does like cases and everything. So um hey, there's one jail people. Where's this one from? Like, I love YouTube. Any what type of hearing? A new Fletcher. I'm fishing. I'm literally fishing right now. Oh God. Someone.
Have a right to an attorney and have a right to have an attorney appointed. If you can't afford an attorney, what's your plans? Are you going to hire an attorney, or have you filled out paperwork for court appointed?
I have already filled out the paperwork for a court-appointed attorney, Your Honor.
Okay. I'll take a look at that and see if you qualify. I'm going to set it for a status hearing. Anything from the state?
No, Your Honor, thank you.
That is all I have for you, Ms. Taylor.
Thank you.
Yeah, I think that's all we have, Mr. Becker. Do you have anything else?
I do not, thank you.
And Ms. Greenwood, do you have anything else?
I don't.
Okay, have a good day.
Ah, dang it, we got here late. Oh, yeah, we got here late. Let's go travel a little bit more. Like, see, but I like that title of that video, Jail People. I think I should title my next video like that, Jail People. I think today is gonna be a hard day, because it's gonna definitely be a very scared day of does any know? I want to watch this one, but I don't know if it is. She's still not talking. Everyone is still like. I still have the other like court on. She's still not talking, so she's a bit boring. Um, there's a Bexar County, but they don't show much. See this one. She's not talking either. I'm like, I don't know what's wrong. And like, oh, she just went offline. Never mind. That's why she's not talking. There is a reason why. Um, oh, I know, Lois. I would love to watch it with you guys, but if I would try to do that here, would it be a bye bye channel? Um, so does anyone know that if the nosy docket, it's a channel or it is a court channel? Because I want to watch the Miami-Dade County felony bond hearings, but I don't know if this is someone's channel or if it is a court channel. Do you know what I mean? Because I want it so much. I've been trying to Google it, and I don't. You know nothing. You don't speak English, do you? Heo, help me. Check your Discord and help me. No, I'm joking. Um, so I know it was you clueless. Okay. It is good with info, but then the thing is there was like Dateline is not always the best place for information because some more likely like by like towards one side, but it is very good to keep information. So yeah. Oh yeah, definitely so many details that I was not even aware either. And that's what got me to go down a rabbit hole about Brian Kobaga, and that's why I'm still not decided if I'm gonna be streaming the trial or not. So I really want to, but I don't know. It's too long of a trial. It's just so long. I don't know. I don't know. So yeah. Um we'll see. Oh, hello, Christy Robinson. Hi, good to see you. Good morning. Hope you are okay. We are looking for something to watch. We are trying to do some court hopping today because there's not much going on in the world true crime. Um world. But yeah, we're just trying to see what's going on, or wait for any judges to um come on and see what we are going to do it. Hang on, I will post CEO. So we are just, if you have any suggestions for us to watch, let us know. Obviously, yeah, exactly. There's so much information that was not supposed to be, that was supposed to be in the cargo, and that's why the judge is very upset. And it is, I think it is already happening, Lois. There's already a investigation happening against the leaks that has happened. She's gone back, come back, hang on. We have one, we have one. We have a live.
And your last client was just logged in, 13 minutes late.
Never late than never.
Okay, on the record in state of Michigan versus Tyrant Stuckey, 2501357 FY.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people. Good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Stuckey. Mr. Stuckey joins us from the Ingham County Jail.
And you said you are Tyrant Stuckey, is that right?
Correct.
Thank you. Today's the date for probable cause conference. Preliminary exam is set for next week, May 30 at 8:30 with Judge Simmons. Have we decided what we're doing?
Thank you, Your Honor. At this time, there has been an offer relayed. I need to have some, we're going to be asking this matter be left on for preliminary exam. The defense will be ready to proceed if we decide to decline the offer. Thank you.
And Ms. Fortuna Gill, you'll be ready?
Yes, Your Honor.
Okay. All right, preliminary exam will continue on May 30 to 8:30 with Judge Simmons. That is in person, sir. So if you are in custody, we'll bring you over for that. If you post bond, make sure you make your way to Judge Simmons' court on May 30 by 8:30 so that this case can be addressed, okay?
Yes, ma'am.
You have a no contact order for Ms. Gonzalez. That applies while you're in jail or out of jail. If you're in jail and you have contact, remember the prosecutor can listen to your calls. They can use your calls against you. They can use your calls to add additional criminal charges. You could lose your phone privileges. You could be in contempt and face 93 days in jail and or $7,500 in fines consecutive to that which you've already faced. If you're out of jail, of course, you're subject to arrest without a warrant, the bond that you posted being revoked, and all those contempt of court penalties that I've already explained. I don't know what's going on with Ms. Gonzalez, but if she were texting you, calling you, sending you JPay messages, she can do that. But if you respond, you're the one who's in contempt. You're the one who's under a court order. She has no authority to give you permission to violate this court order because it's the court's order, not her order. So she invited you to meet up with her or invited you to message her, and you did those things, you'd still be risking jail. Understand?
Yes, ma'am.
All right, anything else for the record for Mr. Stuckey?
Not on behalf of the people, Your Honor. Not on behalf of the defense. Thank you.
All right, Mr. Stuckey, you're done with me today. You'll see Judge Simmons next week. I'm going to disconnect your Polygon. All right, that's Stuckey. Other one I said was Thomas, right?
That is correct, Your Honor.
On the record in state of Michigan versus Tory Thomas, 2501459FY.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people. Good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Thomas, who appears from the Ingham County Jail this morning.
And you said you are Tory Thomas on the video.
Yes.
Thank you. Today is the date for probable cause conference. Preliminary exam is set for May 30, 9 a.m. with Judge Simmons. Have we decided what we're doing?
At this time, Your Honor, we'd be asking this matter be left on for preliminary exam. There has been an offer made. I have not had a chance to relay it to Mr. Thomas due to his custody status, but I am going to do that. Regardless, we will be ready to either plea or run the exam next week. Thank you.
And you'll be ready?
Yes, Your Honor.
Okay. Mr. Thomas, your preliminary exam is currently set for May 30 at 9 a.m. with Judge Simmons. That will be in person. So if you're in custody, they'll bring you over for that. If you're not in custody, you need to make sure you get to Judge Simmons' courtroom May 30 by 9 a.m. so that you can proceed to a hearing, okay? All right. Anything else we need to address for Mr. Thomas today?
Not on behalf of the people, Your Honor. Just that, Mr. Thomas, I will be in touch with you next week, and we will speak prior to the preliminary exam, nothing further.
Okay. All right. Then you're all set with me. You'll see Judge Simmons next week. I'm going to disconnect your Polycom.
All right.
All right, that's Thomas. And then you said you need to speak to Kate, right?
I do, Your Honor. For whatever reason, we have not been able to connect despite efforts.
Mr. Kate, your lawyer wants to talk to you, so I'm going to send your call to a private room. If you click join there, she'll join you in that private room in a minute, so you can have a private conversation.
Thank you.
You're welcome.
Thank you.
You're welcome. All right. Mr. Austin, you said you've already spoken to Brittany Chmielewski.
I have.
There we go. She's got her video on. All right. On the record in State of Michigan versus Brittany Chmielewski, 2501475FY.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
And thank you, Your Honor, and good morning. Jared Austin appearing today on behalf of Ms. Chmielewski. She appears with us remotely via Zoom.
And you are Brittany Chmielewski joining on the video?
Yes.
Yes. Thank you. Today's the date for probable cause conference. There is a preliminary exam set for May 30 at 9:30 with Judge Simmons. Have you decided how you're going to proceed, counsel?
Your Honor, an offer has been extended to Ms. Chmielewski that she informs me that she would like to avail herself of, and the court is willing to put the plea on the record today.
Well, I can take the plea today if you want, but then Ms. Chmielewski would have to be sentenced by me or waive her right to be sentenced by the same judge.
I spoke to her about that, Your Honor, and she would consent to having Your Honor do the plea taking and to be sentenced by Judge Simmons.
Okay, so she wants to waive her right to be sentenced by the same judge. Okay.
That is correct.
I do have
May I
a plea sheet. Thank you. I like to have a written documentation, especially if another judge is going to do the sentence, so she can look back and see what was agreed upon. Okay. All right. So I have to doctor this up a little bit. You want her to plead guilty to count 2.
Yes, Your Honor.
And dismiss count 1.
Yes, Your Honor. My apologies if I didn't do that correctly. There's a different sheet across the hall, so.
Yeah, and I didn't even make this. This is Judge Cherry's or something. He was the judge who was here before me. Okay, and then consent or no objection to 769.4A status. Is that a full statement of the offer?
That is correct, Your Honor.
Okay.
And that's my understanding as well, Your Honor. That's what I've conveyed to Ms. Chmielewski.
And Ms. Chmielewski, that's your understanding what's being offered, plead guilty to the misdemeanor count 2. They'll dismiss felony count 1, and they won't object to you being treated as a first-time offender status if you're eligible. Is that right?
Yeah.
Okay. Domestic violence is a misdemeanor punishable by up to 93 days in jail and or $500 in fines plus court costs, and misdemeanors can carry up to 2 years of probation. Do you understand the possible penalty?
Yes, ma'am.
The prosecutor does not object to you be receiving first-time offender status if eligible. That's a special status that can allow you to earn a non-public record of this case. But you can only have that if you've never been convicted of an assaultive crime, and it does require that you complete a term of probation to earn that non-public record. You understand that?
Yes, ma'am.
If you violate the terms of your probation, you could lose your special status and have the crime enter on your public criminal history in addition to receiving up to 93 days in jail. Some criminal convictions have other consequences. If you are a citizen, foreign travel may be restricted. If you're not a citizen, you may be removed from the country, excluded from admission to the country, or denied naturalization as a citizen. You have the right to have an attorney in this matter, and Mr. Austin is representing you today. You have the right to a trial that could be by jury. You have the right to see, hear, and question all of the witnesses against you at trial. You have the right to bring witnesses in your own behalf, and you could get a subpoena to make them appear. You have the right to testify at trial if you wanted to, but if you did not want to testify, the prosecutor could not use your silence against you. You have the right to be presumed innocent unless they can prove that you are guilty beyond a reasonable doubt. Do you understand these rights?
Yes, ma'am.
And do you understand that you'll be giving up these rights if you plead guilty? There will not be a trial of any kind.
Yes.
Yeah. Okay. If you were on probation, parole, or bond on the day this occurred, May 16 of 2025, and you plead guilty, you could be admitting a probation, parole, or bond violation. As a result of that, there could be a consecutive sentence for your probation, parole, or bond violation. You should also understand that if you proceed with pleading guilty, you may be giving up your right to appeal things that you could appeal if you were unsuccessful at trial. Are you ready to proceed with your plea?
Yes.
Raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth under penalty of perjury?
Yes.
You can put your hand down. Ms. Chmielewski, on May 16, 2025, were you at a location of 1844 Osband Avenue?
Yes.
Is that location in the city of Lansing, state of Michigan?
Yes.
Was David Michael Chmielewski also present at that time?
Yes.
And was he a person with whom you shared a household?
Yes.
You have children in common?
Yes.
And you've been married to?
Yes.
All right. On that day, what happened with David that makes you guilty of domestic violence? What'd you do?
So we got into a mutual agreement, that turned into pushing, which then turned into me getting pretty aggressive towards him and pushing him down.
You pushed him down, is that what you said?
Yeah.
Okay, so you pushed him hard enough to move his body so that he fell to the ground.
Yeah.
And that was on purpose.
Yeah.
And you understand by entering this plea today, you'll be giving up any claims that this was done in self-defense.
Yeah.
Additional questions on the factual basis?
Nothing on behalf of the people, Your Honor.
I'm satisfied, Your Honor. Thank you.
Ms. Chmielewski, did anyone make any promises or threats to you in order to get you to plead guilty here today, other than this plea agreement?
No.
Okay. And are you pleading guilty of your own free choice today?
Yes.
And to the charge in count 2, domestic violence, how do you plead?
Guilty.
I find your guilty plea to be knowingly, voluntarily, accurately made with sufficient facts on the record upon which to base your plea. It's therefore accepted. We'll dismiss count 1 as agreed. I'll refer you to probation for a pre-sentence investigation and determination of eligibility for that special status.
Okay.
And we'll set a sentencing date, but then that's the next thing we have to discuss. Ms. Chmielewski, since you were entered a plea in front of me today, you do have the right to be sentenced by the same judge who took your plea, or you can waive that right and have the sentencing scheduled with the judge you were originally supposed to see, Judge Simmons. The lawyer says that you are interested in waiving your right to be sentenced by the same judge and go see Judge Simmons for sentence. Is that right?
Yeah.
Did anyone make you any promises, tell you that Judge Simmons is gonna give you some favorable deal or unfavorable deal if you go see her for sentence?
No.
Okay, then I'll take your waiver. We'll set this for sentence with Judge Simmons, July 18 at 9 a.m. July 18, 9 a.m. In preparation for that, I do need you to report to the probation department to fill out your questionnaire. So it's tricky because it's Friday. So you need to either come down today by 4:30 to fill out your questionnaire, or Tuesday, because we're closed Monday for the holiday. Tuesday, sometime between 8 and 4:30 to fill out your questionnaire and get your appointment, okay? So you gotta pick either today or Tuesday, get a time, get down here, get your paperwork filled out and get your appointment scheduled. If you don't do that, they're gonna notify the judge that you were non-compliant. So you wanna make sure that you get that done in the time frame as allowed, okay?
Okay.
Just jotting a note here that I wrote by Tuesday because of the holiday. It makes it a little longer than the usual. All right, anything else we need to do for the record for Ms. Chmielewski?
Not on behalf of the people, Your Honor.
I have nothing additional, Your Honor. Thank you.
Last thing, Ms. Chmielewski, is just to remind you that you still have that bond, including that condition of no contact with David. The only contact that is accepted is third-party contact, so nothing direct with him. And the third-party contact's only regarding your children, so it's not about any other topics. So keep following that. If you don't follow your bond between now and sentence, you could forfeit that special status that you're trying to get. So make sure you continue to follow your bond in the meantime.
Okay, thank you.
All right. You're all set. Remember to get down here by the end of Tuesday so you can get that paperwork in.
Okay, thank you so much.
You're welcome. Bye-bye.
Bye.
You're welcome. Thank you. Mr. Davis is at 900 Long Boulevard. Okay. On the record in the state of Michigan versus William Davis, 2501395 FY.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
Mr. William Davis is not here today. He was scheduled for 8:30 for probable cause conference. It is now 9:57. He has not turned up. He unfortunately was denied a public defender. And this is a very assaultive offense. JSG says his tether is at 900 Long Boulevard. So I'm not sure what's going on there. Are you moving for a bench warrant?
Yes, Your Honor.
Due to the assaultive nature of the offense and the fact that we waited an hour and a half for his appearance today, there'll be an immediate bench warrant and bond forfeiture.
Your Honor.
Ready? You have one case left. Is that Kaplan? In the waiting room, we have Aaron Jones and Miles Thompson. I feel like I had one more before. And the jail has just called in. I'm gonna guess it's probably gonna be Johnson.
Right.
Have you talked to all of these people?
Your Honor, I've talked to Aaron Jones.
Okay.
I attempted to talk to Ray John Johnson, but he cut the interview short. Miles Thompson, I've not spoken to. I didn't know where he was.
Okay, so what we'll do is we'll go on the record with Jones so I can clear out that polycom,
Sure.
and then we'll get you in probably with the other gentleman.
Thank you.
All right, Mr. Jones, you're still there?
Yes, ma'am.
Okay, so whenever they use this particular polycom, I can't see you. The video isn't good, so that's why, but we're going to use your audio and get through your hearing today. Your lawyer has just joined us, so we'll go on the record. On the record, state of Michigan versus Aaron Jones, 2501452 FY.
Good morning, Your Honor. Angela Delver on behalf of the people.
Good morning, Your Honor. Jeffrey Kaplan, P74943, on behalf of the defendant, who is appearing by Polycom. And Your Honor, I apologize for being late.
All right, and you said you are in fact Aaron Jones on the polycom, is that right?
Yes, ma'am.
Thank you. Today is the date scheduled for probable cause conference. We have preliminary exam set from 8:30 at 9:30. Have we decided what we're doing?
Your Honor, I have spoken to Mr. Jones. There's not been an offer made in this case yet. I did speak to Ms. Delvero. She said there will probably be an offer. So at this point, we'd like to keep the exam date on, and if we decide to change that, we will let the court, Ms. Delvero, know.
I can indicate to Mr. Kaplan that should my witnesses come for preliminary exam, I will likely not be offering a offer, given the strength of the proofs in this particular case. So if this is going to ultimately be a waiver, I'd like to know that before next Friday. I will not be here next Friday, but I will have someone cover this particular preliminary exam. I can't be here because I'm scheduled in circuit court, as the court knows from my previous record, but this is a particular case where somebody else can cover it, and I will ensure that that is the case.
So Mr. Kaplan, you're clear. You've got to call off witnesses at least a day before during business hours if you want to preserve your negotiating position with Ms. Delvero.
Absolutely.
Okay.
Thank you.
All right. So we'll leave this on for preliminary exam 8:30 at 9:30. That will be in person. So Mr. Jones, we'll bring you over for that hearing. You still have these no contact orders. Those count even while you're in jail. So no contact with any of these folks, Annika, Amelia, or any of the children involved within this case. You have contact. The prosecutor's listening to your calls. They can use your calls against you. They can use your calls to issue additional criminal charges. So make sure you're following all of those orders.
Yes, Your Honor.
All right, anything else for the record
I
today?
don't have anything additional, Your Honor.
For the defense, Your Honor.
All right, Mr. Jones, you're done for today. I'll see you on May 30 at 9 in the morning.
Thank you.
Thank you.
Thank you, Judge.
All right, let me disconnect you. All right, so let me see. You want to talk to Miles first?
Sure.
Okay. Yeah. And then is Aaron back from Kate's? Hello. Okay, so let me get Kate out and then I'll put Mr. Thompson in. Mr. Thompson, I'm going to direct you in a moment to a private conference room to speak to your lawyer. He wants to talk to you. So when this pops up on your screen in a minute, you're going to click join to go into a private room to talk to him. 1 second here. Trying to resituate and get. All right, let's assign Mr. Cates to that room. There we go. No, not Mr. Cates. Stop, don't do that. Oh, see, I messed it up already.
All right, sorry for the break there, but we found, well, I did not find it, is our friend Josh has found us. So for this this trial out of the 14th Judicial Circuit in Florida, got no clue what it's about, but hey, it's a trial, so let's watch. It is the first part, it's rather quick, so we can always, zoom through it, have a speed watch, and have a watch of this case. I don't know anything about it, but we can watch it together. So, oh, sorry, hang on, that was my camera. But anyway, hey 80s music man, Neo and Gamer, good to see you here. It's so nice to see you. It is Katya, it is DCA here today. I am not doing very well today, but I still wanted to do a stream. So yeah, let's just watch this trial out of Florida. This is the best part. We can zoom exactly when they start.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, and please be seated. We're on the record in the state of Florida versus Edward Earl Williams, case number 23 CF 49. Mr. Hill, Mr. Williams is present, appropriately attired. The state is present. Anything before we bring in the jury, counsel? Sir, if you're going to, sir, excuse me, sir, good morning. If you're going to be in the courtroom, please just have a seat, okay? We can't have anyone standing up in the courtroom, okay? Yes, sir. I was saying if you're going to, okay, no problem. Just have a seat. If you're going to be in the courtroom, you need to have a seat. We can't have anyone standing up in the courtroom, okay? You don't have to come up. Just have a seat. Okay, just have a seat. Why can't I sit over here? You can have a seat right there. Just have a seat. Let me remind you, this is a we're gonna have a criminal trial here. We're gonna bring in some jurors. I don't allow input from the audience. This is gonna be your first and only warning. You can't communicate with Mr. Williams. You can't say anything. If you do, if you make any gestures to anyone in the courtroom, any witness, listen to me. Listen to me. Yes, sir. The public has a right to be here. So long as you have a right to be here, so long as you conduct yourself accordingly. Please don't contact or have any communications with the defendant or any witnesses, okay, sir? If you do, I'm gonna have to remove you from the courtroom. All right, anything before we bring in the jurors? All right, let's all stand as the jurors enter. All right, please be seated. Ladies and gentlemen, if you'll remain standing, though, and raise your right hand as the clerk administers your trial oath.
Swear or affirm that you will well and truly try the issues between the state of Florida and the defendant, and you shall have a charge in a true verdict render according to the law and the evidence so help you God.
Thank you. Please be seated. Ladies and gentlemen of the jury, good morning. You have been selected and sworn as the jury to try the case of the state of Florida versus Edward Earl Williams. This is a criminal case. The defendant is charged with aggravated battery. The definition of aggravated battery will be explained to you later. The state's charging document, which is called an information, is not evidence, and it is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusations beyond a reasonable doubt against the defendant in accordance with the law that I will provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of our fundamental principles of our system of justice. Before proceeding further, it is helpful if you understand how trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the court will give you instructions on the law. The attorneys will then have an opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will conclude with final instructions. After the final instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the argument of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case among yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to each of you individually. I have provided each of you with a notepad and a pen for your use to take notes. I've confirmed that there is no writing on any of the notepads. If you'll simply confirm, you'll take your notepads out and confirm there's nothing on the notepads and that each of you have a pen. All right, nothing written on any of the notepads. All right, each jurors indicated that nothing is on any of the notepads. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, the bailiff will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations, the bailiff will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, please notify me by passing a note or informing the bailiff. In the course of the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury trying the case and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during your recesses, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room your cell phone, computer, or other electronic device. If someone needs to contact you in the case of an emergency, the court can and will receive messages and deliver them to you without delay. A contact phone number will be provided to you. This case must be tried by you only on the evidence presented during the trial, in your presence and in the presence of the defendant, the attorney, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit the places mentioned in this trial or use the internet to look up maps or pictures to see any place discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family member make comments to you, or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face to face, you must not talk about this case by using any electronic device. You must not use cell phones, computers, or electronic devices to communicate. Do not send or accept any message related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on the internet, website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to make sure that the information you obtain is proper for the case. The parties, likewise, have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that will require the trial process to begin anew. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. Let me explain to you our daily schedules. As you see, we will begin court at 9:30. We will take a mid-morning break, a lunch recess, and an afternoon break. The court day would normally end during working hours. In the event court may need to continue through the late afternoon, I will assure you, you will have the opportunity to let your loved ones know of your whereabouts and approximate departure from court. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his or her innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial in this case. The parties now have an opportunity to present their opening statements. Mr. Patterson, on behalf of the state. Yes.
Morning. Thank you again for your being here and for your time and attention to this case. The court just told you this is the attorney's opportunity to tell you what we believe the evidence in this case is going to show. What the state intends to prove and what the state believes the evidence is going to show is that on April 7th of 2023, this defendant, Edward Williams, poured a liquid on the victim in this case named Aisha Clay. That liquid is something called liquid fire. It's a caustic substance, acidic substance, and it left significant burning and damage to Ms. Clay. I'll tell you up front, you're not going to hear from any witnesses I don't anticipate you'll hear from any witnesses who saw this incident occur. I believe the evidence is going to show that Ms. Clay and Mr. Williams were roommates at the time, that they were living in the same home together. They were the only two there when this incident occurred. I don't anticipate you'll hear from someone who says they saw it, but you'll hear from law enforcement officers who investigated after the fact. You're going to hear from Police Department Officer Chase, who was the first on scene. He made contact with Ms. Clay. He saw Ms. Clay. He's going to tell you about the condition she was in. We're also going to hear from Officer Nichols, who went to talk to Ms. Clay after she was transported to the hospital in Panama City due to her injuries. He took some photographs, and you're going to see the injuries that occurred to Ms. Clay as a result of this liquid fire substance. I believe you're also going to hear testimony from the emergency room doctor who treated Ms. Clay at the time that she went in. And you'll hear from the EMS who treated her on the scene and was part of the transport to take her to Bay County to the hospital. Most importantly, in this case, you're going to hear from Ms. Clay. Ms. Clay's going to tell you how this incident occurred. Now, When this case is concluded and you've seen all the photographs, you've seen all the evidence, you've heard all the testimony, I don't think you're going to have any doubt that Ms. Clay was certainly injured by this substance, that she was burned on a significant portion of her body by this substance. The issue you're going to be here to decide today is how that substance got on Ms. Clay's body. That's going to be the question that you have to decide based on facts and the evidence and the testimony that you hear in this courtroom. How did that substance, how did that liquid fire? You see the injuries to Ms. Clay, you'll know just how appropriately named it is. How that substance came to be on Ms. Clay's body. Ms. Clay's going to tell you how that happened. And I'm convinced that when you've heard all the testimony, when you've seen all the evidence, you've seen the photographs, you've seen the injuries, you've heard the testimony, I'm convinced that you'll be convinced beyond a reasonable doubt that Ms. Clay is telling the truth, that this defendant, Edward Williams, and her had an argument. And during the course of that argument, he poured this liquid on her. And at that appropriate time, at the end of all the evidence in the case, and when the case is closed and everybody's presented everything they're going to present, I'll have another opportunity to speak to you. And at that time, I'll be asking you to return the only verdict that's going to be supported by the law and by the facts of this case, and that's that the defendant is guilty as charged.
Thank you, Mr. Patterson. Mr. Hill.
Thank you, Judge, counsel. Good morning, ladies and gentlemen. April the 7th, date brings us here today. It was a date, I agree with Mr. Patterson. Miss Clay got liquid fire on her body. It was a day that I agree with Mr. Patterson. Aisha Clay was burned with liquid fire. I agree with Mr. Patterson. The how is why we're here today. The how is where reasonable doubt will exist. Reasonable doubt. You may recall from when we picked juries on Monday, and we went through that process, and we talked to y'all about reasonable doubt. Patterson acknowledged that the state has the burden of proving the charge for which he has filed in this case against Mr. Williams. He bears the burden of proving that charge, and that it happened. Charge happened, and Mr. Williams is the one who committed the offense, and he has to prove that beyond a reasonable doubt. Not only are those the words of Mr. Patterson, at the end of this trial, Your Honor is going to give you instructions. And he is also going to instruct you on the law you are to follow in this case. Your Honor will tell you, again, when he instructs you on the law, that the state bears the burden of proving beyond and to the exclusion of any reasonable doubt Mr. Williams committed the offense that he's charged with. He committed the elements that give rise to the charge of aggravated battery. I submit to you, ladies and gentlemen, that as you listen to this evidence, and at the conclusion of this testimony and the evidence being presented in this case, I will have another opportunity to get back up here and tell you just exactly where reasonable doubt exists as to how Miss Clay got the liquid fire burns on her body. There will be reasonable doubt as to whether or not Mr. Williams is guilty of the crime of aggravated battery. And at the conclusion of the evidence, I will be asking you to return a verdict of not guilty. But for the next little while, I ask that you pay attention to the evidence, listen to the witness testimony, be prepared, liberate. Again, you will find reasonable doubt. Thank you.
Thank you, Mr. Hill. Mr. Patterson, state and call its first witness.
State calls Officer Chase, Your Honor.
Good morning, sir.
Good morning.
You'll adjust the microphone so that we can hear you clearly. If you'll tell us your name and spell your last name.
My name is Officer Jeremy Chase, C-H-A-S-E.
Counsel, whenever you're ready.
Officer Chase, how are you employed?
I'm employed with the City of Port St. Joe Police Department
And how long have you been employed there?
for approximately 4 years.
What do your duties include at the police department?
I patrol, respond to emergencies, have assist the public complete reports.
Do you have any law enforcement experience prior to the police department?
I was a correctional officer for 10 years prior to this job.
So this is your first.
Yes, sir.
Now, were you working with the city of Port St. Joe Police Department in the same capacity back on April the 7th, 2023?
Yes, sir.
Were you on duty that day?
I was.
Did you receive a call to an incident involving a female by the name of Maisha Clay?
Yes, sir.
And how did you get involved in that?
I was dispatched to the address, I believe it was 232 Avenue F, in reference to an agency assist, EMS, and that's where I encountered Miss Clay.
When you encountered Miss Clay, what did you see?
I observed her lay in prone position on her stomach, and as EMS was doing their thing, I was trying to speak with her, and she was in great distress, so it's hard to get anything out of her at that point.
And what do you mean by great distress?
She was, her breathing was labored. You could tell she was in a lot of pain. All she would say was, Mr. Earl Williams throwed acid on me, and then she said it was a liquid fire. It was in a red bottle. And that's all she could give me at that point, because then they had to load her up and transport her to emergency.
At that point in time, were you able to observe any injuries on Miss Clay?
No, she was fully clothed at that point, so I couldn't see anything.
And that was your interaction with Miss Clay at that time?
Yes, sir.
And then she was taken away by ambulance?
Yes, sir.
Now, after Miss Clay was taken by ambulance, what did you do?
She had said there was an individual that had witnessed it. His name was Michael Thomas.
Sustained.
And she said he witnessed it.
Officer, don't share what the victim said.
Okay.
And anytime there's an objection, you need to stop and allow me opportunity to rule on
Yes,
it.
sir. I'm
So
sorry, sir.
I'll sustain an objection. Mr. Patterson, next question.
What did you do next?
I went straight across the street to talk with that individual, the Mr. Thomas.
And did Mr. Thomas give you an objection?
Sustained.
And where did you go after you talked to Mr. Thomas?
I went to 605 Martin Luther King Boulevard.
And is that the address where you understood this incident to have occurred?
Yes, sir.
And what did you find when you got there?
The front door was wide open on the residence. There was nobody there. I knocked, identified myself, but there was nobody there at that point.
The residence was empty?
It appeared to be empty. Yes, sir.
Did you knock to announce yourself?
Yes, sir.
No one came to the door?
No one came to the door.
No one responded?
No, sir.
And then what did you do?
And then I left the residence and went and parked on the other side of the street just to sit there and kind of see if maybe anybody would return to the residence. And then I made contact with, then it was Officer Nichols, to see if he could go to the hospital and get a statement from Miss Clay.
So you stayed there around the residence to see if anybody showed up?
Yes, sir.
Did anybody show up?
No, sir.
And after you talked with Officer Nichols about going to the hospital, what did you do then?
I remained there.
Now, at some point, did you go into the address on Martin Luther King?
Only after Officer Nichols returned, and then we had got us permission from Ms. Clay by telephone, stating that we could go in and search the common areas.
And you stayed there at the home the whole time, Officer Nichols?
Yes, sir, I did.
So nobody was coming in and out?
No, sir.
No one left or entered the home?
No, sir. Not that I observed.
And you stayed there the whole time?
Yes, sir.
When you were in the home, did you take photographs of the home?
I did, sir.
You may.
Sir, Chase, I'm going to show you what I'm marking as state's composite exhibit number 1 for identification purposes. I'm going to ask you if you recognize these photographs.
Okay. Yes, these are the photos I took on the day of the incident.
So these photographs were taken on April 7th, 2023?
Yes, sir.
At the address at Martin Luther King?
Yes, sir.
And where is that home located? Is that here in Port St. Joe?
It is, sir, on Martin Luther King Boulevard here in Port St. Joe. Yes, sir.
And do these pictures fairly and accurately represent the way the home looked at the time you entered it? On
Yes, sir.
2023?
Yes, sir.
Do they appear to be changed or altered or modified in any way?
No, sir.
Your Honor, I'd ask that these be admitted as State's Exhibit.
Any objection?
Objection.
They'll be admitted as State's Exhibit 1.
Officer Chase, did you collect any items of evidence from the home?
I did. We collected one red bottle that was located in the window.
Mr. Chase, send me the number switch.
You may.
Show you what I've marked as State's Exhibit number 2 for identification purposes. Ask if you recognize this.
Yes,
And how can you recognize this?
that is the bottle we recovered from the window in the residence.
You recovered this bottle?
I did.
And so your initials on this
Yes, sir. That's my initials. Yes, sir.
appear to be in substantially the same condition as when you collected and placed it in the bag?
Yes, sir.
All right, that's this be admitted as State's Exhibit number 2.
Any objection?
Objection.
Number 2 will be admitted.
Officer Chase, on entering the residence, taking the photographs, collecting that item of evidence, what did you then do in this investigation?
Once we collected the bottle as evidence, we immediately left the residence.
And where'd you go? Which is?
Went back to the Port St. Joe Police Department where that bottle was bagged and submitted for evidence and stored at the Port St. Joe Police Department's evidence locker.
Now, at this time on April 7th, 2023, did you know who Edward Williams was?
No, sir.
We sit here today, do you know who Edward Williams is?
I don't know Mr. Williams.
Did you make efforts on April 7th, 2023 to locate Mr. Williams?
I did, but was unsuccessful.
Did other officers attempt to locate him as well?
Objection. Speculation.
If he needs to lay a foundation for the basis of his knowledge.
Were you working with other officers on shift that day?
Yes, sir. Me and Officer Nichols.
And Officer Nichols was obviously aware of this case because he had gone to take a statement.
Yes, sir.
Was Officer Nichols also assisting in looking for Mr. Williams?
Up to the point when he come back from the hospital, we then had got permission to go in and search the residence. And then after that, we never did get to locate him after we got everything submitted and evidence. We rode around, tried to look for him, but we never could find him.
So then what was the next step that you took after that?
I started my report. And after I completed those, submitting the evidence and bagging it and all that, then I started on my report.
And what did you do when you completed your report?
I started putting, processing the photos and uploading all that stuff into the evidence drive.
At some point, did you submit for a warrant for Mr. Williams?
Yes, sir. I'm sorry. I did. I submitted a warrant request. Yes, sir.
And following that, what other investigation or involvement did you have in it?
That was pretty much it.
Questions?
Mr. Hill, any cross?
Yes, sir, Judge. Thank you. All right, Officer Chase, direct your attention back to April the 7th. I recall your testimony earlier. You said that when you first saw Miss Clay, she was lying prone on her stomach at 232 Avenue F. Is that correct?
Yes, sir.
All right. And you said that she was fully clothed, correct?
Yeah, I believe as I recall, she had clothes on.
What type of clothing did she have on?
I want to say she was wearing like long pants and a shirt.
You saw no injuries on Miss Clay at the time, did you?
No, sir, I didn't.
Did you ever collect the clothing that Miss Clay was wearing?
No, sir.
Why not?
I didn't. That was a mistake on my part. I didn't think to do that.
So we don't have the clothes that Miss Clay was wearing on April the 2nd, correct?
Correct.
You told the jury that you sat across the street from 605 MLK until Officer Nichols got back, and then you and he went inside y'all went inside the house at 605 MLK Drive, correct?
Yes, sir.
When you went inside the residence at 605, what did you first observe?
There was stuff in the floor and stuff like that. The house appeared to be in disarray.
When you say there was stuff in the floor and stuff in the house, what describe for the jury what type of stuff we're talking
It's just random, like clothes and stuff on the floor. Best I can remember, they might have been one of the cushions on the couch was laid in the floor.
So there were some couches. Let me ask you this: when you first walk in the front door, is it like a living area?
Yes, sir. It's a living room. I would say a living room.
Okay. And you mentioned couches. Were there couches in that room?
There was one.
Okay. Was there any other type of furniture in that room?
Not that I recall. I don't remember.
Were there any rugs or any type of floor covering?
I think there was carpet on the floor.
Carpet on the floor?
I believe so.
Okay. And you believe there was at least one couch?
Yes, sir.
Possibly a couch cushion removed from the couch?
I think so. Yes, sir.
When you examined this living room area, did you find any evidence, or did you see any evidence that an acidic or caustic substance had been splattered, poured, or anything of that nature?
No, sir.
Was there any damage to the couch cushions consistent with a caustic substance being poured?
Not that I observed.
The carpet that was on the floor, was there any evidence on the carpet of a caustic substance being poured on the floor?
Not that I observed, sir.
When you examined this room, did you see any evidence of a caustic substance being splattered or sprayed in that room?
Not that I observed.
When you entered that room, you said you collected this red bottle. Where was the red bottle when you first entered the room?
It was in that window sill to the left of the door in the room.
Was anything else in that window sill?
There was a black leather wallet that had Mr. Williams' Florida ID card.
Okay. Was that collected as evidence?
I took a photo of it and left his wallet and his ID card there.
Besides the living room area, did you examine any other parts of that residence as far as when you investigated that? You're there investigating, you're there to collect evidence. Besides the initial room when you walk in the front door, were there any other rooms in the house?
There were, but all we did was we went in and cleared the house, and then we backed out. I began photographing as we walked in the house. When we entered the house, we photographed the bottle where it was found, located in the windowsill with the wallet. And as soon as we located the bottle that we were looking for, we ended our search and departed the residence.
Okay. So you immediately ended the search after finding the bottle?
Yes, sir.
But as far as doing any further investigation to find out where in the house or how in the house that this incident occurred, there was no further investigation?
No, sir.
Nothing further, Judge.
Any redirect?
Officer Chase, you were asked a lot of questions about the room. You photographed and documented the record, correct?
Yes, sir.
So the pictures would accurately reflect the way that room looks.
Yes.
And does that picture accurately depict the bottle of liquid fire and the wallet where it was located?
That is correct, sir.
It also shows the couch and the couch cushion on the floor.
Yes.
Now, you were asked a lot of questions about whether there appeared to be any sort of, I guess, caustic substance that may have eaten the carpet or the cushions. Let me ask you this. Did it appear that there had been a struggle in that room?
It looked like something happened there, but I mean, I didn't observe any, like where something had been splattered and maybe eroded the contact.
But the room is kind of a mess.
Yes, sir. It was in disarray. Yes, sir.
It appeared that there could have been a fight or a struggle in that room, correct?
Yes, sir.
All right, may Officer Chase be released? All right, Officer Chase, sir, your testimony has concluded at this time. The lawyers may have additional questions for you later on. Please do not discuss your testimony with anyone but the lawyers, okay?
Yes, sir.
Yes, sir. right, ladies and gentlemen, what we're going to do, we're going to take a 10-minute recess. Please remember my prior admonitions. Don't discuss the case with anyone, including amongst yourselves. But at this time, we'll take a 10-minute recess and we'll all stand as you exit the courtroom.
Oh, break time and quick Kimbers, Ohio. Hello, welcome, and definitely we'll have a look. Yeah, I'm sure we'll find a way to watch that, but I'm sure hoping. And yeah, so good thing with watching trials is we can zoom through breaks and go exactly where they are. I love zoom through breaks. It is awesome of just doing this. I think this was what, more than a 10-minute break there, Judge, but Judge and their punctuality.
Anything we need to discuss before we bring in the jury? All right, let's all stand as the jury. There's someone on Zoom, Brandy, I believe Hollingsworth.
It should be Brandy Midstead, Your Honor. That is the doctor, the ER doctor.
Okay, she your next witness?
Not next.
Okay. All right, Ms. Judy, the individual that's with us by Zoom, we'll just leave them in the waiting room.
Yes, sir.
All right, thank you. Be seated. All right, Mr. Williams is present. Does the defense recognize the presence of the jury?
Yes, sir. Judge.
State recognize the presence of the jury?
Yes, sir.
All right, Mr. Patterson, call your next witness.
State Colonel Sergeant Nichols.
I do. All right, good morning, sir.
Good morning.
If you'll tell us your name and spell your last name.
Richard Nichols, Nichols.
All right, counsel, whenever you're ready.
Good morning, sir.
How are you employed?
I'm employed with the Port St. Joe Police Department.
In what capacity?
I'm a patrol sergeant.
And what are your duties included as a patrol sergeant?
I have two officers that work under me and basically ensure that they're doing their job. And then I also do pretty much everything they do as well.
And how long have you worked for the city police department?
July the 13th will be 5 years.
Do you have any law enforcement experience prior to that?
No, sir.
Were you working for the city police department back on April the 7th, 2023?
Yes, sir.
During the course of that day, did you become involved in an incident involving a Maisha Clay?
Yes, sir, I did.
How did you become involved in that?
Officer Chase called me and stated that he had a battery and asked that I travel to the Sacred Heart Hospital in Panama City and interview Miss Clay.
Did you do that?
I did, yes, sir.
Did you make contact with Miss Clay in the hospital?
I did. She was in a bed in a hallway, was medicated, and I took some photos and spoke with her there.
You may.
I'll show you what I've marked as state exhibit number 3 for identification purposes. It has to be recognized these.
Yes, sir.
What are these?
These are the photos I took of Miss Clay that were in the hospital in Bay County.
And do those photos fairly accurately depict the condition of Miss Clay at that time?
Yes, sir.
They appear to have been changed or altered or modified in any way?
No, sir.
Your Honor, that's to be admitted as state exhibit 3.
Any objection?
Objection.
State's exhibit 3 will be admitted.
Officer Nichols, after your contact with Miss Clay at the hospital, what did you do?
I traveled back to Port St. Joe and spoke more with Officer Chase. We then decided we needed to search the residence, and I again spoke with Miss Clay via phone and got permission to go in the residence.
So you assisted Officer Chase in the search of the residence?
That is correct.
What was your involvement after the search of the residence was completed?
After Officer Chase collected the bottle and we left the residence, that ends my involvement with the case.
Did you ever at any point in time make contact with Edward Williams during the case?
No, sir.
Did you attempt to locate Mr. Williams?
Yes, sir. I believe we looked around the residence whenever we went in to search, but we never made contact with anyone there.
Did you ever make contact with him at any point that day?
No, sir.
Mr. Hill?
Sergeant Nichols, when you made contact with Miss Clay at the hospital, was she still wearing the clothing that she had on her at the time of the incident?
I don't know exactly what she was wearing at the time of the incident, sir. I was never on that actual scene.
What was Miss Clay wearing when you saw her at the hospital?
I believe she had a gown on, but I would have to look at the photos to be 100% accurate.
Did you collect any clothing that Miss Clay might have been wearing at the hospital?
No, sir, I did not.
You returned to the residence eventually and helped or assisted Officer Chase in searching the residence and collecting the evidence, correct?
That is correct.
Did you search or examine the residence beyond the room just inside the doorway?
Whenever we entered the residence, we did clear the entire house. Then we back up to the front door and began searching there. We located the bottle in the windowsill and I believe a wallet. And after that, that's where we stopped.
So you went through the residence to clear it. And when you say clear it, what, for the jury's benefit, when you say clear the residence, what are you talking about?
We just cleared it of any people to make sure there was no one in there with a weapon that might be wanting to harm us, something like that.
So when you're clearing a residence, you're looking to make sure there's no persons or people in the residence.
That's correct.
You're not examining the residence for evidence or examining a crime scene or anything of that nature.
That is correct.
So once you cleared the residence, nobody was in there. Y'all returned to the initial living room area.
Yeah, that's correct.
Found the bottle and that was it.
Correct.
Nothing further, Judge.
Any redirect? All right, may Sergeant Nichols be released from his subpoena? All right, Sergeant, thank you. You're released from your subpoena. You did pretty well about your day, sir. Thank you for your testimony. Mr. Patterson?
Let's take on Brandy Scott.
Yes.
All right, ma'am, good morning.
Good morning.
Would you tell us your name and spell your last name?
Brandy Scott, SCOTT.
Thank you. The attorneys will have some questions for you, beginning with Mr. Patterson.
Good morning.
How are you?
I'm employed by Gulf County EMS.
What do your duties include with EMS?
I'm a paramedic on the ambulance.
What does paramedic mean?
We assist with like 911 calls, emergency calls, medical calls, treat patients, and take them to the hospital.
Were you working with Gulf County EMS back on April 7th of 2023?
Yes.
And were you called to a scene involving a female by the name of Maisha Clay?
Yes.
And when you got on that scene, what did you find?
She was laying on the ground in, I believe, a neighbor's yard. She was rolling around on the ground, saying that she had, someone had put liquid fire over her.
And what did you do from there?
We put her on our stretcher and took her to the ambulance, and we transported her to Bay Medical Center.
And what did you do during transport?
On the way to hospital, we observed, and she had some white residue on her. We cut her clothes off, and I did IV on her. I gave her some pain medication, and I notified the hospital that she was considered a trauma alert, and it took us like 35 minutes to get there with her.
And what does that mean, a trauma?
Trauma alert is a criteria. If there's any injuries in the state of Florida, you have a criteria that you go by. And she had residue on her. We wasn't for sure what it was, and she had some blistering come up. And if it's anywhere around the airway, we call trauma alert.
What do you mean by blistering?
She had, on the way we got to about Mexico Beach, she started getting just big blisters on her neck, her chest, on her legs, on the back of her legs, and her arms.
And in your experience as a paramedic, what did those blisters look like? What did they appear to be?
From a burn, like a 2nd-degree burn.
Did she appear to be in distress or pain?
She was. She was rolling around a lot initially when we got there on the ground. Once we got her in the truck and cut her clothes off, and I gave her a little pain medicine, she calmed down a little bit.
You administered pain medicine to her in the ambulance?
Yes, sir.
When you got to the hospital and turned her over, did you have any more involvement?
No, sir. Once we get there, we turn them over to the staff.
Now, so you mentioned these blisters showed up as you were traveling.
Yes, sir.
What did the marks or injuries, or what did you observe before they began to blister?
It was just there was like white residue on her, and it started getting red before the blisters popped up. Her skin was red.
And then the blister will be formed.
Yes.
Mr. Hill?
No question, please.
All right. May Ms. Scott be released from her subpoena?
Yes, sir.
Ms. Scott, ma'am, you are released from your subpoena. Your testimony has concluded. You're free to go about your day. Thank you.
Just take a call, Dr. Brandy Midstead.
All right, Ms. Reese, if you'll admit the individual that's in our waiting room.
Yes, sir.
Ladies and gentlemen, the next witness you're going to hear from will appear virtually by Zoom. That was by agreement of the parties. Ms. Judy, you'll just let us know when she arrives.
Judge, it is connecting to audio.
He said,
While she's connecting, I'll mark this as stage 2 and 4. This is the medical records from the emergency room visit. This is the emergency room doctor. I'm asking to be admitted.
any objection, Mr. Hill? Okay, State's Exhibit 4 will be admitted. Dr. Is it Milstead? Doctor, are you able to hear us in the courtroom, ma'am? Ms. Judy, was the doctor able to connect?
Judge, it still says connecting to audio.
Okay. Counsel, your office may have to contact the doctor and tell her to log out and log back in. Okay.
Computer audio. It says
Okay,
I'm
Dr.
on.
Hill. All right, Dr. Milstead, good morning.
Okay, there you go.
Dr. Milstead, could you hear? There we go.
Can you hear me?
Yes, would you raise your right hand to be sworn, ma'am?
You swear affirm the testimony you give in this case to be the truth, so help you God.
Yes, I do.
All right, doctor, would you tell us your name and spell your last name?
Brandy Milstead, Milstead.
All right, Dr. Milstead, welcome. The attorneys here will have questions for you. If for whatever reason you cannot hear us, I know there's a slight delay between us here in the courtroom and you appearing virtually. Please just let us know. Or if you do not understand any of the questions, please just let us know. Okay, ma'am?
Yes, sir.
Mr. Patterson?
Good morning, Dr. Milstead.
Morning.
Dr. Milstead, how are you employed?
I'm an ER physician at Ascension Bay in Panama City Beach.
How long have you been employed there?
Since 2017.
And how long have you been a physician?
I graduated medical school in 2013.
And what is your medical background, or what is your educational background?
I'm an ER physician. I went to medical school at UAB in residency in Virginia, the Virginia Tech Carilion Clinic. And then I graduated residency and I came to Panama City Beach, Florida. And I've been working at the same hospital since graduation of residency.
And were you working at that hospital on April the 7th of 2023?
Yes, sir.
And did you, on that date, treat a patient by the name of Maisha Clay?
Yes, sir.
And what did you treat her for?
Chemical burns from a substance that was splashed on her is what she told me. Sulfuric acid.
Did you treated those burns in the emergency room?
So yes, she presented as what's called a trauma alert. And when we have a trauma alert, there's a team assembly of a trauma surgeon, an ER physician, nurses, techs, and we all conglomerate. And anytime there's a significant burn, we activate a trauma alert. So she presented as a trauma alert because of her skin burns.
And burns of that significance, do they leave permanent damage and scarring?
Yes, sir, they definitely can.
Now, outside of treating her in the emergency room, you didn't treat Miss Clay beyond that. Is that correct?
Correct. I only interacted with her on her initial day of presentation.
But the severity of the burns that you treated were burns that would leave permanent scarring and disfigurement.
I mean, they certainly could. I don't know what happened to her after she saw me, but she had significant burns enough to be a trauma alert.
Mr. Hill?
Good morning, Dr. Milstead. Can you hear me?
Yes, sir.
Thank you, ma'am. So you treated Miss Clay for chemical burns on April the 7th. Is that what I understand your testimony to be?
Yes, sir.
And Miss Clay told you that a substance was splashed on her? Is that what I heard you say earlier?
Yes, that someone threw something on her.
During the course of treating Miss Clay, did you request any lab work to be performed on her?
I'd have to review my notes. I'm sure that it's documented in the notes what labs were ordered. There's a typical lab evaluation that we run on our trauma patients. So she probably had that.
And does that lab work include blood work?
Yes, sir.
Would a alcohol or ethyl alcohol test, is that a standard lab work that you would run on someone coming in as a trauma patient?
Pretty standard. We don't do it on every single patient, but almost all of them.
Okay. Do you know if if you had ethyl alcohol tested on Miss Clay when she came to the emergency room?
I'd have to defer to my note.
If it's in the medical records, would it have, if it's listed in the medical record, would it have occurred?
Correct.
And I believe you testified that after you treated Miss Clay in the emergency room on the 7th, you had no further dealings with her after that. Is that accurate?
Correct.
Okay, thank you, ma'am.
No redirect? All right, Dr. Milstead, thank you for your testimony, ma'am. You're free to go about your day. You're released from your subpoena.
Thank you.
Mr. Patterson?
Thank you, Hannah, for that. I was a little bit distracted. Just a little bit of an issue. Let's just skip.
Swear on the testimony you give in this case, the truth, so help
Yes.
All right, good morning.
Good morning.
Would you tell us, you can adjust the microphone. Would you tell us your name and spell your last name?
Maisha, last name Clay, C-L-A-Y.
All right, Ms. Clay, the lawyers will have questions for you, beginning with Mr. Patterson.
Like, can you also spell your first name for the court, please?
Maisha, M-I-E-S-H-A.
Clay, where do you live?
Panama City.
Where were you living back on April the 7th, 2023?
I moved to, I was in Fort St. Joe.
You live in Port St. Joe?
Mhm.
Where were you living?
I had moved to
Matilda's house in Liberty Manor.
Sorry,
In Liberty Manor?
can you talk into the microphone?
I was in Liberty Manor.
Well, I want to take you back to an incident that occurred on April 7th of 2023. Do you recall that day?
Yes.
What were you doing that day?
I was going to retrieve my last of my belongings from Earl Williams' house.
Your belongings were at Earl Williams' house?
The last of them.
Why were your belongings at Earl Williams' house?
Because I stayed with Earl Williams and I moved out
How long did you stay with Earl Williams?
about 6 months.
Where did you stay with Earl Williams?
On Martin Luther King and Tony Larry's house.
So what were you doing on April 7th, 2023 at Mr. Williams' house?
Retrieving my last of my belongings.
And what happened when you got to Mr. Williams' house?
I sat down and was waiting for my ride to come back. And I don't know. That's all. Yeah. Waiting for my ride to come back.
Okay, so you're sitting there and you're waiting on your ride to come back?
Yes.
Okay, then what happened?
Somebody said,
Somebody said.
oh, sorry.
Unless it came from Mr. Williams, Ms. Clay, you can't tell us what someone else said, okay?
Okay. I was sitting on the couch and Earl Williams came over me and said, I will burn you up.
Now, who said that?
Earl Williams.
Now, just so we're all clear, the Earl Williams that we're talking about, do you see him in the courtroom here today?
Yes.
Can you point him out, please, and describe what he's wearing?
Button down shirt, black pants.
Now, I'm going to ask you a question. It's going to seem silly, but this address is 506 at Martin Luther King, where you were staying with Mr. Williams.
Mm-hmm.
Is that in Port St. Joe?
Yes.
Is Port St. Joe in Bell County?
Yes.
Okay, so you're sitting there waiting on your ride. Mr. Williams comes over and says he'll burn you up. Then what happens?
Then he was standing over me and I was on my phone, on one phone, and I was texting another phone. So he came over me and I guess started pouring, but I didn't feel nothing here. So I didn't feel nothing. But I got up to run and it hit me here. And I didn't feel the burn until I got to the back door.
Okay, so he poured something on you. Is that again?
Yes.
Initially, you didn't feel anything?
No.
Okay, so then what happened?
I run out the back door and I start splashing water out of a bucket on my body. And I fall to the ground. And then he was coming behind me and people were saying, get up, he's coming after you. So I run across the street and I fall out. That's the only thing I remember.
And then what happened after you ran across the street?
I was on fire. I didn't know I was on fire.
Okay. I know it's maybe difficult. I know you're using phrase, but I want you to describe what you mean by you were on fire.
It's burning everywhere. Everything was burning. My chest, my legs, my tongue, everything. Everything was on fire. I was burning. Like somebody had just doused me with, it wasn't like fire. It was like, I can't describe it. There's nothing I can say.
Was it painful?
Yes.
So you go across the street. What do you remember happening after that?
I don't remember nothing happened. I remember in an ambulance and they're trying to calm me down. And I remember at the hospital where they sprayed me down with a water hose and
So the next thing you remember after going across the street is being in the ambulance.
on the ground. On the ground. So then I went on the ground. And the next time I remember in the ambulance.
I want to back up for a minute to the incident in the house. When you went over to the house to retrieve your belongings, was Mr. Williams there?
Yes.
Were you able to gather up your belongings?
Yes. They were already at the front door.
So you were just sitting there waiting on someone to come take you and your belongings away?
Yes.
That's because I believe you said you moved to Liberty Manor?
Yes.
Let me see, was the relationship, you stated you lived at Mr. Williams' house for about 6 months.
Yes.
Was the relationship with you and Mr. Williams romantic?
No.
Y'all were just roommates?
Yes. Yes.
Were you able to see what was poured on you at the time that it was poured on you?
No.
Um, so you just felt it, you didn't actually see it?
I just felt, I didn't actually feel anything at first. But as I was running out the back door, he was coming behind me with the bottle in his hand.
Were you standing up or sitting down?
I was sitting down.
Was he standing up or sitting?
He was standing up.
And do you know, like you said you didn't feel it, do you know, did it pour onto you?
It poured. I think the bottle's like a squeezable bottle. So it started here, in here, and on down.
Let me ask you this. I can see there where you just pointed, you have a scar on the side of your face.
Yes.
Is that a result of this incident?
Yes.
Did you have that scar before April 7th of 2023?
No.
You man.
I'm going to show you. I'm going to show you what I've marked as states number 5 for identification purposes.
Yes.
What did you say that?
The burn, the acid.
These photographs of your body?
Yes.
And were these photographs taken sometime after this incident?
Yes.
These photographs fairly and accurately depict the injuries that you suffered on the day that these photographs were taken?
Yes.
They appear to have been changed or altered or modified?
No.
States number 5.
Any objection, Mr. Hill?
No objection.
States 5 will be admitted.
It's like when Mr. Williams said that he burned you up, did he appear angry?
No.
Y'all having an argument?
No. I think it was drug induced.
No. Have you had to receive medical treatment as a result of these injuries?
Yes. I had 2 surgeries, skin graft, possible sepsis off the limb.
Are you still scarred to death?
Yes.
I'd ask to publish this.
You may publish.
This is states number 5. Ms. Clay, where in Mr. Williams' home did this take place?
Living room, the living room.
Living room? Um,
You may.
show you what's been admitted as State's Exhibit number 1. Is that the home where you live, Mr. Williams?
Yes,
Is that a photograph of the living room area?
yes, yes.
And where were you?
There's a couch on the other side.
So you weren't on this couch?
Mm-mm. I was on the other
Yes,
side.
please.
She can answer, re-answer that question, where was she at?
Right, so this is the photograph you were looking at. Where were you in relation to this?
There's a couch on the other side, right here. By the window.
And you'll make sure the witness
Right
is
here.
speaking into the
Oh,
microphone
sorry.
so that
There's
the
a
jury
couch,
can hear.
there's a couch right here by the front door, right up in here. That couch is on that wall, the other couch is on this wall.
Okay, so there's a couch that's not depicted in this photograph,
Right,
and that's the couch you were sitting on.
right.
So you mentioned, I asked earlier if there was if Mr. Williams seemed angry or if there was an argument or something going on, you said no.
Right. There was something said, but but
There was something said beside, "I'll burn you up."
well, it's not missile, is it? It's done by somebody else. So it's not missile, right?
Is it something Mr. Williams said?
No. Okay.
Now, what you mentioned earlier, I think you said that you thought Mr. Williams might have been drinking.
It's on meth.
Were you drink?
I had a drink with me.
So you had consumed alcohol this day?
Yes.
This claim will ask you to do something, and it might be a little difficult. But I want you, if I may, Your Honor, have her step down and show her scars to the jury.
That's, unless there's an objection, and that's perfectly fine. And of course, I'm not sure where they're located, but no private areas.
I've already instructed her that they're not in any area that should be seen.
Okay, you can step on down, ma'am. Ms. Clay, if you wish. And Mr. Hill, you can reposition yourself if you want.
First one, you have the scar on your face. Now, you turn to the jurors and see. And you're described, is that the area behind your knee there?
Underneath the skin graft.
So you had a skin graft on there? Okay, so I want to be clear. The spot on your right leg here, that's not from the incident, correct?
No, that's where they took the skin.
That's where they took it.
This is skin from here. All this skin from here.
So they took skin from here to try to fix your chest and your other leg. So I'm going to ask you one last question. How did you get those injuries to your body?
By Earl Williams. Pouring acid on me. Pouring a substance that I didn't know what it was then. So
That substance caused those burns?
yes.
All right, question right here.
Mr. Hill?
Thank you, George.
All right, Miss Clay, you stated or testified, I'm sorry, earlier that on April the 7th, you were at, I believe you said 506 MLK. Is it 605 MLK? Is that the address?
I'm not sure.
Okay. But you were at this house that we've seen the photographs of.
Yes.
And your purpose for being there was to retrieve the last of your belongings. What belongings did you have in that house?
Clothing
Okay.
and personal hygiene stuff.
Okay. And was it, you testified that was at the front door?
Yes.
Okay. Did you have anything else there at the house?
Nothing I was taking with me.
And you were waiting on your ride to come back?
Yes.
Who was coming to pick you up?
I was waiting for I don't remember.
You don't know who was coming to get you?
I don't know who's gonna get me.
You were there to retrieve your belongings.
Yeah.
I mean, did you have them in a storage too?
They're in a like the laundry bag, like the condo laundry bags, you know.
The what bag?
Like the condo laundry bags, you know, they held the linen in.
Like a linen bag?
Yes.
So all your stuff was in a linen bag just inside the front door?
Yes.
And you testified when we were looking at the photographs, and if I may approach the witness.
You may.
You look at that photograph. Does that photograph depict the couch that you were sitting on?
Yes.
If you will, point in that picture to the couch that you were sitting on in this, so the one on the right-hand side?
Yes.
Just inside the door?
Right here.
Okay. Approach the jury.
You may.
You were sitting on the couch, right-hand side, just inside the door.
Yes.
You said Mr. Williams was standing up over you, correct?
Yes.
And your testimony is that while you were seated, Mr. Williams was standing, that he poured this substance over you.
Yes.
When the substance started hitting your body, where did it hit your body at first?
I guess here. Because I didn't feel nothing until I got to get up to the doorway. Then all of this started running first, because I guess this was the baddest.
When Mr. Williams, as you testified, started pouring the stuff, did you immediately jump up? Or how soon after the stuff started hitting your body did you jump up?
I guess I don't know how to answer that one. Can you?
You said you ran out the back door of the house.
Yes.
And you started splashing yourself with water. Where did the water come from that you started splashing yourself with?
There was 2 buckets on the side of the Earl Williams house on the next property. There's a boat and 2 buckets.
Okay. And those buckets just happen to have some water in it?
Water and tadpoles and everything, I guess.
And from there, where did you run to?
Across the street.
after you stood up and ran out the back door, did Mr. Williams pour any more?
No.
The substance on you as you were running away from him?
It had to be. I don't know, but it had to because it wasn't. I mean, if you're starting here and I get to run this way,
You were sitting on that couch.
on the couch, and then get up to run, get to run. So it had to be here.
What were you wearing?
Shorts and a t-shirt.
You were wearing shorts and a t-shirt?
Yes.
You recall what type of shorts they were?
I think cotton shorts. They weren't jeans. I don't think.
You were not wearing any long pants?
No, I was wearing shorts.
And you said you and Mr. Williams were not in an argument and there was no anger between you two of you at the time this incident happened, correct?
No, there was no anger. I mean, just
You said you had been living at the house?
I haven't. I moved out.
Had there been any issues with the toilet stopping up?
Yes.
And in fact, toilet being stopped up needed liquid fire and Drano to clean it, correct?
No, sorry, Mr. Tony Larry had bought some stuff like prior to me moving out, and we had poured it in the toilet. It's drugs, so she bought some drugs. We poured it in the toilet. So that was like maybe a week before then.
So there had been issues with the toilet needing something poured in it to clean it out.
Yes.
And liquid fire is a substance that can be poured into a toilet to clean it out, correct?
Right. I guess I don't know.
Did you tell the emergency room doctor when you were being treated at Ascension Bay that a substance had been splashed on you?
No.
You didn't?
No, not splashed on me.
How long had you been at the house that morning before this incident happened?
Not long. I mean, maybe 20 minutes.
These belongings that you were there to retrieve, that you said the last of your belongings, had you already gathered them up on a previous time and just put them inside the door?
Yeah, I gathered them up. They're in the back room where I sleep with, and I got there. They were in the front.
They had been in the back room and you had moved them to the front?
No, they had moved to the front.
Okay, so they were at the front. You were waiting on your ride to come back. How did you get there?
I had been there earlier, been in the neighborhood earlier.
So you were in the neighborhood just doing your thing?
No, I was in the neighborhood. Came to the neighborhood from Liberty Manor.
How did you get from Liberty Manor to the neighborhood?
I think my cousin. I'm not sure.
Okay. And was your cousin the one that was going to take you back, or was somebody else going to take you back over there?
I don't remember.
You don't remember who was coming to pick you up?
No.
That's all the questions I have right now.
Okay, Mr. Patterson, any redirects?
Explain. Before this date, did you know what liquid fire was?
No.
Do you know what it does?
No.
What it's used for?
No.
You know if it has a legitimate purpose?
No.
Did you know it was in the house?
He had said that he had purchased something for the toilet. I mean, but I never did see it. So
you never saw it?
I never saw it.
And you were asked about how it could have got on you. You're not entirely sure because you were running away? Is that how I understood your testimony?
Yes, when I got to run, it had to be it was poured here. So it's poured here. I mean, there's no other way. Because I was sitting down. So
Just so I understand your testimony correct, the effects were not immediate.
no, it from like here to the hallway was about maybe the end of that that back chair maybe, and then it starts to burn. Everything started to burn.
And you don't, so after getting across the street, you don't really remember anything at that point other than being in the ambulance and going to the hospital. Is that correct?
Yes. But he was coming after me when I was running across the street. He was coming out the back door after me. So
It's like these scars that you have, are they ever going away?
no.
Mr. Hill, any other questions?
No, sir, Judge.
All right, then Ms. Clay be released.
I asked that she remain your lunch break.
Okay. All right, Ms. Clay, your testimony at this time has concluded. The lawyers may have additional questions for you. Please do not discuss your testimony with anyone, but you may, however, speak with the lawyers. Okay, ma'am?
Yes.
All right, thank you. All right, counsel, you approach.
Oh, another sidebar. This kind of like sounds Karen retrial. Oh, they might adjourn on this one. Hang on. Let's see what the judge. I think they might send them for lunch, but we can zoom. Do not forget, we have another feed.
All right, ladies and gentlemen, after discussion with the attorneys, we're going to take our lunch break at this time. Based on where we are in the trial, we're moving quicker than I anticipated. So we're going to have a lengthy lunch break. It is 11:34. I'll ask that you all return at 1 o'clock up to the courthouse, and we'll resume.
Right, we don't need to listen to the judge sending them to lunch because we listen to that on a daily basis, literally. But because we are zooming through this trial, we can literally go to the next part, to the part where they come back from break, where they come back from lunch, and I'm just setting up. So far, I mean, he seems pretty guilty from my side from all the testimony that we have heard so far, but we'll see what happens on the afternoon session, I guess.
Any additional witnesses you want to call at this time?
I want to bring Ms. Clay back very briefly.
Okay. And the state will rest after Ms. Clay's testimony? What I intend to do then, once you rest, I don't want to bring the jury in for 5 minutes and then let them go back out again. Well, basically, I'll ask the attorneys to approach. Any motions we'll take up at sidebar during that time. Mr. Hill, do you intend to call any witnesses?
Mr. Williams take a stand. I have to.
All right, Mr. Williams, you raise your right hand for me. All right, Mr. Williams, Mr. Hill, you can have a seat. Mr. Hill informs me that you wish to testify in your own defense. Is that your decision? You understand that you do not have to testify. You have the right to remain silent. And if you chose not to testify, I will instruct the jury, as I did this morning, that they are not to consider your decision not to testify in any way. And if you do testify, I will instruct the jury that they are to treat your testimony as they would any other witness. You understand? And if you testify, I don't know your background, but if you have any convictions, felony convictions, the state or Mr. Hill will be able to ask you if you've previously been convicted of a felony, and if so, how many? And they will also be able to ask you if you've previously been convicted of a misdemeanor involving dishonesty, and if so, how many? You understand that? Does Mr. Williams have any prior felony convictions?
We discussed that, yes, sir.
Okay. You understand that that's going to come out if you testify? If you do not testify, the jury will never hear that. You understand that? And it's your decision to testify, and you're doing so on your own free will. Have you had a sufficient amount of time to speak with Mr. Hill about that? All right. Any other questions, counsel?
Sir.
Mr. Patterson?
Okay.
All right. So what we'll do is we'll bring the jury back in. We'll recall Ms. Clay. Once the state rests, we'll have our brief meeting sidebar, and then we'll proceed with the defense's case in chief. And we'll do our jury charge afterward once Mr. Hill rests. All right. Anything else, counsel?
Judge, Mr. Patterson indicated that Ms. Danny had emailed instructions to Ms. Judy. Ask her if you can forward me that email so that when we take a break, I can go down and print proposed instructions, because I don't have a copy of the proposed instructions yet, so.
All right, Ms. Judy, do you hear Mr. Hill?
No, sir, I did not.
Would you forward to Mr. Hill the email we received with the proposed verdict form and jury instructions?
Yes, sir, I will.
All right, thank you. Anything else, Mr. Hill? All right, we'll all stand as the jury enters. All right, thank you. Please be seated. Ladies and gentlemen, I hope you enjoyed your lunch break. And does the state acknowledge the presence of the jury?
Yes, sir.
And Mr. Hill?
Yes, sir.
All right, state, you can call your next witness. Okay. All right, Ms. Clay, if you'll resume the witness stand, ma'am. Ms. Clay, you're still under oath, and the attorneys will have additional questions for you, okay?
Yes.
All right, Mr. Patterson?
This may seem like a strange question, but it has to be asked. Did you want this substance poured on you?
No,
Did you ask me way to have this substance poured on you?
no,
Volunteer in some way to have this poured on you?
no.
Mr. Hill?
Nothing further, Judge.
All right, Ms. Clay, may she be released or she's still under the rule?
I've asked you, man.
All right, Ms. Clay, ma'am, just stay around the courthouse and remember, don't discuss your testimony. Mr. Patterson?
Statements.
Okay. Counsel, can I see a sidebar with the court reporter and Mr. Williams?
Man, this definitely sounds like Karen Reed trial with all that this many sidebars. Like I'm having flashbacks now.
Ladies and gentlemen, the state has now rested its case. Mr. Hill?
Good state call, or defense calls Edward R. Williams.
All right, Mr. Williams, you remain standing as the clerk administers your oath. In front of judges, ma'am. All right, Mr. Williams, good afternoon. If you'll tell us your name and spell your last name.
Edward Earl Williams, William W-I-L-L-I-A-M-S.
All right, the lawyers will have questions for you, beginning with Mr. Hill.
Yes.
Tell us where you live at, Mr. Williams.
Right now, I live in Cobb County Jail.
Okay. Before that, where do you live at?
I lived on Main Street, 262 Avenue, Main Street, Martin Luther King.
How long did you live at 605? Okay.
I think about a year, maybe.
While you were living there, let me direct your attention back to April the 7th of 2023. Is that where you're living at 605 Martin Luther King?
Yes, sir.
Did you have anyone living there with you?
Yes.
Who was living there with you?
Naish.
How long had Miss Clay been living with you there on April the 7th of 23?
I say about 6 months.
Anyone else living in the house with you?
No, sir.
Prior to April the 7th, had you been having some issues with the plumbing, the toilet?
Yes, sir.
Tell the jury what type of issues you've been having.
The commode full. I couldn't. No, it looked like everything I bought wouldn't work. Nothing. So I had to go and borrow some money from a partner of mine, and I went up to Ace Hardware. And when I got on that line, I seen Drano, stuff like that, which you unclog stuff with. Well, I had used Drano before, and it hadn't did too much. And so I went to the guy, and he came down the aisle with me, and I said, show me something that'll make this stuff get out of my drain pipes. So he showed me that red ball. I said, I had never seen it before, never used it before. So I said, you sure this gonna work? And he said, if this don't work, then you need to take the plumbing out and put some more plumbing in. That's what he told me. So I said, okay. And I'm thinking it wasn't going to be that much. It cost me $42 for that bottle. That stuff in that bottle. I said, $42. He said, yep. So, but I had to have it. So I got back to the house. And when I got back to the house, the first place I went, I said, well, if this stuff is this strong, then this PVC ain't gonna last too long. That's what I'm saying to myself. So I went to the kitchen and I pulled some down in the sink. Well, I kind of seen a little smoke come out of there. I said, it must be working. So I walked in the bathroom and I pulled some down in the bathtub. Well, I pulled a lot of it down in there. It's going directly to the main line. And I went to the commode filled up with paper. I just pulled and pulled and pulled. And I'm looking. And it went spew smoking. And you could smell the fumes. It got so bad, I'm an asthmatic. I got out, walked to the front door. And I looked back like this. I said, girl, you don't smell that stuff. I said, this stuff too strong for me or you to stay up in here. I said,
you said when you look back at the girl said, talking about how strong it was, who are you talking about?
I'm talking about Naisha.
Where was she at?
She was laying on that couch, the first couch.
Just inside the doorway?
Inside the doorway. So I said, you don't smell that stuff? I said, look at the smoke coming out of the bathroom. So it was coming out real bad. So I said, you better come out of there. So I stepped on the outside the door. When I did, I could still smell it. And I come back in, I say, girl, get up and get out of here. Them the words I said. Just like that. No arguments, no nothing had occurred before, none of that.
What happened next?
I did it like this. I said, girl, read this. Do you see what's on this bottle? This is poison. Come out of here. And when I went to come back like this, she kicked the ball. She kicked it. That's why I got this stuff on my hand. When she kicked that ball, I drew back because my face was like this, just like this, to the ball. Her face is like this. And I'm telling her, see this ball? You see what's on this ball? And before I could get it all the way back, she kicked it. And when she kicked it, some of the stuff got on me.
Did some of the stuff get on her?
It had to, cause when I jumped back and got over there to that woman, she jumped up and went to running to the back door. And I'm looking, and then it went to I ran to the back door behind her. When I did, she out the back door. I come out the back door, she ran to the road. When she got to Avenue, what the F? Yeah, Avenue F. When she got to Avenue F, she fell. And when she fell, she was hollering and screaming, rolling like that. I said, somebody call the ambulance and get the ambulance to come see about it.
Okay.
I did that.
Did you have a phone on you?
No, sir.
Now, Ms. Williams, did you pour, at any point in time, did you pour that substance in that red bottle on Maisha Clay inside that house?
No, sir. Let me say this. Sir.
Let me ask you this.
Okay.
You said you didn't pour it on.
No, sir.
All right. Did you set the red bottle in the windowsill where it was shown in the photographs in this case?
I'm the one put it there.
All right. And in that windowsill, was there also a wallet with your identification?
With my ID in there, yes, sir.
You set that bottle in that windowsill?
Yes, sir.
Right by the wallet with your identification in it?
Yes, sir. Yes, sir.
You were not trying to hide the bottle, were you?
No, sir. It was in plain sight.
You went out the back door. Miss Clay ran to the roadway. You said she fell down. Where did you go to after that?
After I went out there and told them somebody to call the ambulance, I walked back to the house. And the ambulance came up to get her, put her in the ambulance. And I shot the ball back there. I said, oh man, I'm going to jail. That's what I said. So another guy came up and said, what happened? I said, she kicked this ball and the stuff and got on her, and that's why she got to go to the hospital. I said, but I didn't try to do this until that lady. And as long as it was an accident. She kicked it. I defend it. When you kick it, anything can have. Something got on me. So I'm like, why you kick this ball? That's what I want. She ain't never asked that question. Answered it yet.
Have you ever been convicted of a felony, sir?
Yes, sir.
How many times?
I think 5, 6, maybe 7 times.
Could be 8.
It could be 8. Yes, sir. I ain't gonna deny that. I've been there.
Mr. Patterson?
Where you lived with Maisha for 6 months, correct?
But she lived with me for 6 months. Yeah. Oh, okay.
Y'all lived together for about 6 months.
Yes, sir.
How long were the plumbing problems at?
I'd say about a good 2 weeks. It was off and on until it got like it did. So
And she moved out at that point?
he was off and on, in and out, in and out, in and out. So until she said she was gonna move.
I understand your testimony to be that you purchased this liquefier.
I did.
The day that this happened?
Yes, sir. That's the day I got it. The same day that this happened, that's the day I went and got it.
You said you poured some in the sink.
I poured it in the sink.
It started smoking.
Went to smoking.
So you went and poured a bunch in the
Bathtub.
it went to smoke.
It went to smoke.
In fact, it went smoking so bad that it run you out of there. Right?
Yeah.
So it was obvious this stuff was bad, right?
It was already, it showed up got bad when I put it in the commode.
What I'm saying is it was obvious.
Oh yeah, poison. I knew it was poison.
Right?
I knew it was poison. I read the label on it.
Now, your testimony was that you started trying to tell her to get out of the house.
I did.
Okay. You're trying to get her to look at the bottle.
I brought the bottle to her and let her look at the bottle. And she still wouldn't move.
And your testimony was that she kicked the bottle.
She kicked it.
Just so I'm clear, I understood your testimony. Y'all weren't fighting?
Nope.
No argument?
Nope.
No fussing?
Nope.
No yelling?
Nope. None of that. Nothing like that.
Everything was calm.
Everything was calm.
When you showed her the bottle, she just kicked it.
That's when she kicked it. I ain't have no problem with her, no kind of way, shape, form, or fashion. No arguments, no nothing. And that's what got me. I didn't know why she kicked the ball. What she kick it for?
Now, you said you followed her outside. You hollered for some other people to call.
Called ambulance. I didn't have no phone. No.
And you went back to the house.
I went back to the house.
But you didn't stay at the house.
Nope. I walked back down the road there.
What'd you do that for?
She was in the ambulance and gone.
Okay. But you just testified this was an accident, right?
It was an accident.
So where'd you go?
Walked back up out Luther King. Didn't get far. I said I got the Avenue D.
Why didn't you stay home?
I ain't gonna. What I'm gonna stay home for? I got no reason to stay home. She gone and I'm out.
Told Mr. Hill earlier that you thought you were going to jail.
Oh yeah. But that kind of stuff on that girl, you know how I'm going to jail. They go first thing they gonna think.
But it was an accident.
It was an accident. Either way it went, I was coming to jail.
Why would you go to jail for that?
You just don't know these police. And I was going. Cause she already done told them. I told it on.
Oh, she told them.
She told them while she was laying there. She told them. She's the one that initiated. She's the one told them. When I walked away from that girl, she'll get in the ambulance. A friend of mine walked up and say, "Earl, what happened?" I say, "I'm going to jail." He say, "Why?" I say, "This him."
So you didn't stay around.
I didn't stay there. I walked up. I didn't try to run or none of that. I walked up the highway.
I understand, but you weren't there with law enforcement.
No,
You didn't stay around to explain how this.
I didn't stay there. I walked up the road just as slow as when I knew anything, the law was gone. When I did get back to the house, law was gone. I never tried to run. I stayed right there on Martin Luther King.
Did you see the law sitting out in front of your house? You never went back to your house to see if anybody showed up?
I ain't never go back. I went back. It was way later when I went back down there, and the reason I really went back down there was to close the door. That's the only reason. The front door, her stuff was there in the front, and I went there and I closed the front door. But the fume was so bad, I let the back door stay open.
You never spoke to law enforcement, did you?
Not that day, no sir.
Talk to law enforcement either?
I can't remember when they got me, but I never said too much to them.
What do you mean by when they got you?
They eventually picked me up for it, but I never had nothing to say at all.
Mr. Hill. All right, Mr. Williams, you can have a seat next to your attorney. All right, Mr. Hill, any other witnesses?
It's a risk, Judge.
Okay, ladies and gentlemen, as I suggested, we're moving along faster than I thought. We're going to take another break. I have some matters, as I explained earlier, that I need to discuss with the lawyers outside your presence. But when you return, we should be able to get this case to you concluded so you can begin your deliberations. I will all stand as you exit the courtroom.
Sorry about that.
Thank you.
I
Please be
pressed the
seated.
button.
All right, Mr. Patterson, does the state intend to present any witnesses on rebuttal? Okay. All right, let's have our charge conference. But with Mr. Williams, with that testimony, is there anything we need to discuss, sir? Aside from your testimony, everything is going fine with the trial? Any complaints about anything? Okay, and you're satisfied with Mr. Hill's services so far? Anything you wanted Mr. Hill to do that he has not done? Okay, all right, counsel, let's have our charge conference. You have your, okay, no problem.
All right, so let's just skip this boring part because I think they're just going to throw.
So I have jury instructions, first page, reads members of the jury. I thank you. Straightforward.
Let's go see what they say here. Oh,
And
yeah.
as always, what I'll do, counsel, I'll read the preliminary instructions. I'll read.
Let's just skip this. They take a break there, and then they are back now shortly. So we are gonna go straight into closings. Oh, there's more people in the gallery now. There's is that the guy back? No, I don't know if he's ever gonna come back. Let's.
Yes, sir. And your motion is timely based on Mr. Williams' testimony. I believe this is a question for the jury. All right, we'll all stand as the jury ends. Thank you. Please be seated. Jury has returned. Both the state and defense present, with Mr. Williams present as well. Mr. Hill.
It's rest at this time, Judge.
Members of the jury, I thank you for your attention during this trial. Please listen carefully to the instructions I'm about to give you. Edward Earl Williams, the defendant in this case, has been accused of the crime of aggravated battery. To prove the crime of aggravated battery, the state must prove the following two elements beyond a reasonable doubt. The first element is a definition of battery. Edward Earl Williams actually and intentionally touched or to structure that extension for the battery will. Next, Edward Earl Williams calls Maisha DeShonda Clay is entitled to divide their time.
Told you this morning that we would have another chance to speak to you after all of the evidence in the case has been presented, and you have now heard all of the evidence, seen all the evidence, and heard all the testimony that will be presented in this case. As I told you this morning, there was going to be some things that the evidence showed that were pretty obvious, that were going to be easy boxes to check. The judge just read the instructions to you and he read the elements of aggravated battery out. There's two elements to aggravated battery. First element is that the defendant, Edward Earl Williams, actually and intentionally touched or struck Maisha DeShonda Clay against her will. We'll come back to that. Second element is that in committing the battery, Edward Earl Williams intentionally or knowingly caused great bodily harm to Maisha Clay or permanent disfigurement to Maisha Clay. You saw the injuries to Maisha Clay. They're as permanent as they can get. They're not going anywhere. She's going to bear those scars for the rest of her life. Second element has been proven. There's photographic evidence. You saw it with your own eyes on Miss Clay's body. Now, as I told you this morning, this case is going to come down to how that got on Miss Clay's body. Not if it got there. We know it got there. We saw the results. Heard the EMS testimony, you heard the doctor testimony, you see the photographs. We know it got there. We know contents of this bottle wound up on Miss Clay's body, causing severe burns to her face, her chest, her stomach, and her leg. Heard some different stories about how it got there. I told you this morning too that I didn't think there was going to be some magic witness who saw all this happen that was going to come in and tell you that you were going to have to determine it based on the evidence and testimony that you heard. And I want you to think back to that evidence and that testimony. Ms. Clay told you she'd been living with Mr. Williams. She'd been moving in the process of moving out. She still had some items over there. She went back to get those items. She's sitting on the couch, waiting on her ride. According to Miss Clay, Mr. Williams comes in and says, "I'm going to burn you up," and proceeds to pour this item on her, this liquid on her. So she doesn't immediately realize what it is or what's happening. It doesn't have an immediate effect. Then it starts burning. Then it starts kicking in. She runs out the back door, trying to splash water on herself out of the bucket, trying to put out the fire. She runs across the street where she falls down, and EMS gets called. EMS arrives on the scene, and EMS told you that she's rolling around on the ground. They get her loaded in the ambulance. She's in severe distress and pain. They give her something for the pain. She begins to blister. They say, EMS testified, they told you that she was covered in a white-looking substance, and they know what it was. Then it started to blister and burn. They called it as a trauma patient. Now, Ms. Clay has maintained from the outset how this happened. This case boils down to two varying stories of how this liquid wound up on Miss Clay. You've gotten to hear both of those versions today. It's your determination to make about which one is reasonable, which one makes sense. When you put on those juror badges this morning, nobody told you to leave your common sense out in front of the courthouse. You can use that in determining which one of these stories makes sense, which one of these stories match up with the other evidence you've seen. You heard the judge read off of this with the rules that you have that you can look to help you make a determination. Now, I have a chance to break this up. I have another opportunity to speak to you. At that point in time, I'll be asking you to return the verdict that's supported by the facts, by the story that makes sense. And that's that the defendant is guilty, is charged of aggravated murder. Mr. Hill?
No anger, no argument, no motive. No anger, no argument, no motive. How did the substance get on Ms. Clay? That is the question that the state has to prove to you beyond a reasonable doubt. How? There's no doubt that that substance got on Ms. Clay. Not arguing that. It's the how and whether or not there's reasonable doubt to prove to you how it happened. You've heard from Ms. Clay. You heard from Mr. Williams. They both told you how it happened. Has either version convinced you beyond a reasonable doubt to the other, to the exclusion of the other? Did Ms. Clay's version of the events convince you beyond a reasonable doubt to the exclusion of what Mr. Williams told you happened, sufficient that you can find him guilty in this case? That's your question. It is to the evidence introduced in this case, and it alone, that you are to make that decision. You, ladies and gentlemen of the jury, get to decide which evidence you find to be reliable. You can find that evidence is reliable. You can find that evidence is unreliable. The judge has instructed you on that, and you'll receive a copy of it. Let's take a look back at the evidence and what we have seen and heard during our trial today. And I'll begin with our first witness. Just go through the witnesses in order. Officer Chase testified that this, when he saw Miss Aisha Clay, that she was fully clothed. He recalled she was wearing long pants and a shirt. No observable injuries did he see on her. So she was fully clothed, no observable injuries, and then she went to the hospital. And it was at the hospital is where Sergeant Nichols or Officer Nichols made contact with Miss Clay. I asked the officers, ladies and gentlemen, did either of you ever collect the clothing that Miss Clay was wearing in this instance? Two officers, and neither one of them collected the clothing as evidence to bring to you today to show you what she was wearing. Was any of this substance that got on her, did it burn her clothes? Did it tarnish her clothes? Did it stain her clothes? We don't have any of that evidence because the officers didn't get it. Officer Chase and Officer Nichols, after they speak to Miss Clay, they come back to the house. They're going to do they believe that a crime has been committed. They want to examine the scene of the crime to collect any evidence and bring the evidence that they need to this case to court. They got a job to do. Examine the crime scene, take photographs, collect evidence. What did Officer Nichols tell you? He's a sergeant. He has officers that work under him. And one of his responsibilities is to make sure that those officers do what they're supposed to do. Make sure those officers do what they're supposed to do. And I submit to you, ladies and gentlemen, that Officer Chase didn't do it. Even the sergeant who told you his duty was to make sure that other officers do their job, he didn't even do it. What did they not do? Did they do a thorough investigation? Did they do a thorough examination of this crime scene? Absolutely not. They went inside the living room, took a few photographs, saw a bottle. We're done. We're done. We got a bottle, we got a few photographs, and we're done. I asked the officers, did anyone do any examination to find out where inside the house this incident took place at, to confirm or to corroborate what you're being told? We've got 2 couches. We've got a rug on the floor. We've got carpet on the floor. Did anybody look at the photographs to see, or look at the scene to see if there was any evidence of a caustic, acidic substance being on those, either one of those? Burning it, tarnishing it, staining it? Nope. We took a few pictures. Did you go through the house to see if there was any other evidence inside the house? Nope. Right there. Ladies and gentlemen, we've got 2 couches that are shown in this picture. You may recall that Miss Clay told you that she was sitting on this couch right here. That's the couch she was sitting on when Mr. Williams, as she told you, stood over her and poured this liquid fire onto her. Poured it on. Ladies and gentlemen, my next comment is not meant to diminish the nature of the injuries that Miss Clay sustained in any way. But you saw the photographs, and then you saw her demonstration here in court. You got one photograph that shows blistering on her chest area. Few marks on her stomach in that photograph. Burn marks on the backside of her leg. Another picture of her stomach area. Ask yourself, ladies and gentlemen, do those photographs depict injuries consistent with someone having a substance poured on top of them? Those photographs show evidence beyond a reasonable doubt that a caustic substance was poured on top of her and drained down? Or is it consistent with what Mr. Williams told you? He testified that she was laying on her side. Laying on her side. He showed her that bottle. What did she do? She kicked it. Kicked the bottle. We have the most serious injury that is depicted is on the backside of her leg. Ladies and gentlemen, if she is seated down on that couch and a substance is being poured on top of her, how and why is the most serious burn injury on the backside of her leg? I'm seated right here. Burn is on the back of my leg, but yet I'm being poured on from the top. Is it not reasonable to think that your most serious injuries will be up top, not down bottom? Miss Clay told you that she was there to retrieve the last of her belongings. Where were those belongings at? They were just inside the door. They were in she described it, a laundry basket that the rental companies used to put dirty laundry in. Officers did give us a few pictures of the inside of the house, ladies and gentlemen, and you'll have an opportunity to take these photographs back when you go to deliberate. But I show you that photograph showing just inside the doorway. Do you see a laundry bag with clothes just inside that doorway? Another picture inside the living room. This here appears to be a TV. You can make your own conclusion as to what it is, but it appears to be some type of TV or monitor. You can see that there. And if you look real closely, you can see it just inside the doorway right here on the left. Couch cushion, presumably from right there. A close-up of the bottle. But what do you not see? There's no laundry bag of clothes just inside that door, as she told you it was. As she told you why she was there, what she was doing there. Ms. Clay told you that Mr. Williams said, "Oh, to burn you up." Is that, gentlemen, how much sense does that make? You already heard Ms. Clay tell you there was no anger, there was no argument, there was none of that going on. How much sense does it make that you're going to just out of the blue make a statement that I ought to burn you up when there's nothing of that sort going on? You're just going to randomly come up to somebody and say, I ought to burn you up. Does that make sense, ladies and gentlemen? Absolutely not. Absolutely not. I told you that twice. Told that initially, and she testified to it again. She's right. No anger, no argument. Yet she wants you to believe that Mr. Williams told her, I ought to burn you up. But after this stuff got on her, she ran outside the back of the house and found a bucket that had something in it. She wasn't sure what it was, some kind of liquid, and she started splashing that stuff on her. Started splashing on her. She was burning. She ran across the road and she fell prone, and that's where she was when the ambulance got there. Something else you consider, ladies and gentlemen. I don't know what was in the bucket. Ms. Clay doesn't know what was in the bucket. Look at the blisters here. Look at the blisters back there. Look at those blisters. Those scars. Are they consistent? You need the jury. You get to decide. Is the same substance that caused the injuries up here, injuries on the substance, on her stomach? Is it the same substance that caused the blister on the back of the leg? Don't know. Was there something in that bucket that she was splashing herself with that caused the injuries to the back of her leg? We don't know. But proof is in the pictures. There's different scarring, there's different blistering. You get to decide. You heard Mr. Williams, he testified, and he told you that he'd been having some issues with the plumbing. He went to Ace Hardware and Drano wasn't working, so some gentleman at Ace Hardware told him, you need to get this. If this doesn't work, you're gonna need new plumbing. This is good stuff. So he told you that he got it, poured it in the drain in the sink, and it started fuming, started smoking. Like, oh, this is obviously doing something. This is some good stuff. Poured some of it in the sink, went to the bathroom, poured some of it in the drain in the tub. And he went to the toilet. The toilet was really stopped up, so he poured quite a bit of it in the toilet. Then he told you he went back into the living room where Miss Clay was laying on the couch, seemingly unaffected by what was going on. He's like, "Do you not smell this? You need to leave. You need to get out." Goes out. She's not coming, so he goes back in there. Hey, do you not see this stuff? You realize what this is? We need to get out of the house. We don't need to stay in here. This stuff is smoking. He told you that she kicked it. She kicked the bottle out of his hand, or in his hand, kicked the bottle. And at that time, stuff splattered out the top. Stuff got on him, stuff got on her. Look at these photographs, ladies and gentlemen. Is that consistent with a substance being poured on top of you? Something being splattered out the top of a kicked bottle? That evidence of it being poured on you, or evidence of a little bit of it being splattered out the top of the bottle? As you go through these photographs, some are duplicates. You'll see a photograph like that, but remember Miss Clay told you that was on her right leg where she had skin grafts. That's not an injury that's caused by the substance in this case. The back of her leg. How did she get that on the back of her leg? Did that get on the back of her leg from Mr. Williams pouring something on top of her as she's sitting down? Or did that get on the back of her leg when she kicked the bottle, exposing the back of her leg, and the substance came out and got on her leg? Has the state proven beyond a reasonable doubt that Miss Clay received her injuries as a result of Mr. Williams pouring this substance on her? Ladies and gentlemen, when you're back there looking over this evidence, there's something else that you can take a look at. Top of that red bottle. You may not be able to see it right here, but when you're back there in the deliberating room, you can take a closer look at the photographs. You'll see that there's all type of liquid residue around the top part of that bottle. You have to ask yourself, ladies and gentlemen, if someone is pouring something out the top of a bottle, is it going to get all over? Comes out the spout. If they're simply pouring something out, is it going to get all over the top of the lid, the flat lid? Is it going to get over there, simply pouring it out? Did all that liquid residue get on the top of that bottle when it was kicked and the liquid comes out the top? What makes more sense to you? If the top of that bottle was wet from being poured out, being kicked out. Ask Miss Clay about the stuff on the back of the leg. She couldn't tell you she couldn't explain how the stuff got on the back of her leg. You don't want to admit it didn't get there from Mr. Williams poured it. It got there because she kicked the bottle. What we have, ladies and gentlemen, into this case, answer the question how. I'll leave you with this. No anger, no argument, no motive equals reasonable doubt as to how. Reasonable doubt equals not guilty. I ask that you find Mr. Williams not guilty as charged. Thank you.
Mr. Patterson? No anger, no argument, and no motive. Two things about that. One, it works both ways. Two, you give these jury instructions. We talked in jury selection and you took an oath and you made a promise that you weren't going to require the state to prove things that the state's not required to prove. I don't see anything on this paper that says that Edward Earl Williams angrily touched or struck Maisha Clay. I don't see anywhere on here where it says Edward Earl Williams touched Maisha Clay during an argument. Or that he had a reason or a motive to touch Ms. Clay. Those are fun words to say, but they're not elements of the crime the state has to prove. Don't require the state to prove things the state doesn't have to prove. A story that doesn't make sense is the story of the bottle. The reason it doesn't make sense is because it got made up way after the fact. It didn't happen. The way this got on the back of her leg is she told you when she was running away and he was chasing her. You don't run away from an accident. Particularly not in a home you've lived in for 6 months. You don't run away from an accident. You go to the sink, in the kitchen, or the bathroom. You try to wash the stuff off. You take one of the cell phones you had. Ms. Clay testified she was texting somebody on. And you call 911 to help. You don't run away from an accident. You run away from an attack. You run away from an attacker. One that's chasing you still. One of the things the judge can tell you, and one of the things he read to you earlier in your rules for deliberation, I'm sorry, you're weighing the evidence, is one of the things for you to consider is, did the witness have some interest in how the case should be decided? Here's how this anger, argument, motive thing works both ways. There was no, I agree. Nobody testified here that there was any anger, there was any fight, there was any argument. Which begs the question of why would Miss Clay make up the story to lie and get this person she lived with for 6 months in trouble? She wouldn't. She's just telling the truth of what happened. She has no reason. They weren't in a fight. They weren't in an argument. She's moving out. She's leaving Mr. Williams behind. There's no reason for her to tell a lie about how an accident occurred in order to get Mr. Williams in some kind of trouble. There's no motive for her to do that. She's simply telling you what happened. She told you that I asked her about it. I asked her, she said that there was substance abuse involved. That makes rational people do not rational things. Like pour liquid fire on somebody. The other thing, there's this mountain out of the molehill situation with what she was wearing. Miss Clay told you she was wearing a t-shirt and shorts. The officer said he thought she had pants on. The officer that saw her for a span of 15 seconds while she's writhing on the ground, and EMS is trying to tend to her, and he's trying to figure out what the heck happened, and who the heck did it, and where it happened, and what's going on, and she can't talk. She's in pain. Is it ridiculous that the officer didn't really notice what she was wearing? Everybody's human. He's got a lot of things going on. He's trying to take information. He's trying to write. He's trying to do all these things. But out of the realm of possibility that he didn't take a mental photograph of what she was wearing. Or Miss Clay would know what she was wearing. Or her clothes. And at the end of the day, it doesn't matter what she was wearing. The stuff got on her. The stuff burned her leg. That's a distraction from how the stuff got on her. The officer did do an investigation. Third Officer Chase testified that Clay told him who did it and what it was. He went to the home, found exactly what she said right there, had his weapon, collected it, tagged it, put it in evidence. At that point, is there a need to go looking around the rest of the house? She told you exactly what it was, where this happened, what it was, and you found it right there where she said it was, like she said. There was this thing made about what was in the bucket. Well, Miss Clay said it was water in the bucket. I think at some point she even said, if I remember right, that it had tadpoles in it. Well, tadpoles aren't living in something that would do that to your leg. We know it was in the bucket. It was water in the bucket. She's trying to cool herself off. She's on fire. There was law enforcement didn't do an investigation. They didn't look at carpet, they didn't look at couches, they didn't look at this, they didn't do that. That's because the stuff hit Miss Clay. It's not on the couch, it's on Miss Clay. It's not on the floor, it's on Miss Clay. absolutely no possible way that this stuff could have ended up in all the places it ended up because it got kicked out of the defendant's hand. Just physics says it can't happen. It's on her face. It's on her chest. It's on her stomach. It's on the back of her leg. It's on both sides of her, front and back. There's no way it went in all those places on one kick. When you look at these photos of her leg, that's not a drip that got on her leg. That's not a splash or a dash. It came out of the can when it got kicked. That's a volume of this stuff that did that. There's not a space on her leg that did that. Now, another thing I want you to keep in mind when you look at these photos is that these photos are taken at different times. One thing we know about burns is, again, common sense, burns progress. They change over time. These are the photos from the hospital, the day of the incident. That's State's Exhibit. These photos are some months later after she's had skin grafts and work done. But they all exist to show you that this damage is permanent. It's not going anywhere. You don't run away from an accident. You know who did run away? Edward Williams ran away. Oh, what it is, he fled. He got out of there before law enforcement showed up. He didn't stick around to explain, well, I was trying to get her out of the house and she didn't want to go. And we tussled and bottles spilled. Or I was trying to get her out of the house and for some crazy reason she kicked the bottle out of my hand and it got all over her. No, he was gone. Don't run away from an accident. But it is likely you run away from a trip to jail. You know you poured this liquid on this person. Now she's out of the house and the cat's out of the bag and EMS is coming, which means law enforcement's not going to be far behind. I better get out of here. What is reasonable? Is it reasonable to think this play kicked this bottle, ran out of the house, instead of going to water sources in the house, rolled around in the yard, wait for EMS to show up, trip over there to the hospital, and did all of those things, and then kept that going for 2 years, from April 2023 to now May of 2025. Edward Williams, she started from the minute she got contacted saying it was Edward Williams. He told EMS. He forwarded this on. Told the doctor. The doctor initially used the word splash. I think she then changed it from splash to, I remember serving correct. She changed it from splash to pour or through. So he threw it on her. People don't lie to their doctors. People want to get treated correctly. This is the story she made up last week. This is the story she's been telling since April the 7th of 2023. Again, Who has an interest in the way this case turns out with their testimony? Not going to change anything. Miss Clay is still going to be burned. She's still going to have her scars. Now, the rest of her life, they're never going to. I'm not going to harp on it or pound on it or jump up and down, but there's a reason that it exists in the instructions. There's a reason you're told that you can consider whether or not the witness has been convicted of a felony. Start to consider it when the witness has been convicted of a felony. There's only one story here that makes sense. There's only one story that's reasonable. There's only one story that's been consistent for 2 years. That's the story of Maisha Flood. She didn't run away from an accident. She ran away from an attack. A vicious attack. It's left her scarred for the rest of her life. We'll have all these items to go back with you. You've heard 2 versions of events here today. One of those versions was facts on April 7th, 2023. The other was a story. One of them has been being told since April. One of them was due today. I asked you to consider the evidence, consider the fact. Return the only verdict that's supported, the only verdict that makes sense, the only verdict that's reasonable. That's the defendant is guilty, is charged with aggravated battery.
Ladies and gentlemen, these are some general rules that will apply to your discussion. You must follow these rules in order to return a lawful verdict.
Right, let's pause the judge on the rules and let's pretend we heard them, and let's move on to the verdict, because let's end the poll first. Let's pretend that we are on verdict watch and we are going to do some parole hearings while the verdict is not there, because I'm imagining it's going to be a rather fast verdict. So 1:55, and I think they came back. I'm trying to see when did they come back. Oh, well, they come back there. So I think they deliberated for almost an hour. So let's come back to it. I think it's a verdict. There is a verdict, and let's play the verdict music. So by now a verdict. So let's watch what the jury decided on the verdict. Yay. That was a quick verdict. I know. Verdict music is always good.
All right, I believe Mr. Patterson may be getting warm outside the courtroom. Yes, sir. Yes, sir. All right, Mr. Patterson, Mr. Hill, I'm told that we have a verdict. All right, anything before we bring in the jury? All right, okay, so we'll all stand as the jury enters the courtroom.
It's confirmed, it's a verdict.
All right, thank you. Everyone, please be seated. Ladies and gentlemen, I'm told you have reached a verdict in this case. All right, ma'am, if you will please pass the verdict form to the bailiff. The verdict form is in order. Mr. Williams, I'll ask that you stand with your attorney as the clerk publishes the verdict.
Court, 14th Judicial Circuit of the State of Florida in Fort Gulf County, State of Florida versus Edward Earl Williams, case number 2349CF. We, the jury, find as follows as to the defendant, Edward Earl Williams, in this case. The defendant is not guilty, so say we all. Dated this 22nd day of May, 2025.
Thank you. Would either counsel like the jury polled? Right, thank you. Mr. Williams, please be seated. Ladies and gentlemen, I wish to thank you for your time and consideration in this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon jurors.
Dang it, Denise was right again. I know. I absolutely. Wow, not guilty. This is crazy. See, this is why I get nervous when Denise plays the verdict game. She gets not guilty. She always gets it right. Always. And this is why I was trying to decide with Denise, but then I trusted Josh, and I kept my Am I the only one now? I stood with the guilty. Denise is the only one. Denise is the one that won. Congratulations, Denise. You won the verdict game apparently again. Because he always says like, see, this is why I stopped playing. This is this is why we should trust our I'd same Kimbo, same I don't even have a brain to start with, Denise. Now might as well a jury brain. You're funny. You're funny. First of all, I need to get the brain. I know this is absolutely incredible. I feel bad for the for the victim though. I mean, she has to suffer with all the scars and everything for the rest of her life. Well, at least he still only has 8 felonies, and at least he can get out of jail now and go free and go to whatever he was doing before. That is crazy. Yeah, I think I'm gonna stick with Denise's opinion next time. Definitely, Denise is she's our expert on verdicts for a reason. Same. That's what I said, Hannah. That's what I said. That was definitely what I said. Right. So that was absolutely the only one you got right was Sarah Boone. I think I got some right, but there's some that I'm still very angry on. But Stephanie, I don't know. Like, I do trust you, but with my sense of directions and sometimes confusing my left from my right, I'll probably go right instead of going left. No, don't quit, William. I need at least 6 months notice. You can't quit. You can't quit. I need 6 months notice though. Sorry, but you can't. Well, she has been wrong before. Denise has been wrong before, but I think she's getting her status back slowly, very slowly, because it's been a while since we've been having since we've been having a verdict drought and long trials. But she still get it very much right on. So now the last one for today, again, another suggestion. Oh, I can say that word now. From Josh is that a defendant or someone wanted to fire everyone in a courtroom, apparently. So it's in Judge Wolf's courtroom. This is a great judge. So let's watch that one and make sure that I can put the sound on so we can hear it. Well, I did put a little bit behind where you told me to be, so hopefully we can hear it.
We do need Mr. Fan here at 1:30 for the interpreter to be able to let Mr. Talbot speak with him and explain what is going on. So. Bring out Mr. Vaughn. Here's Mr. Vaughn. Oh, yeah. So is Mr. Vaughn set for trial? Okay. How long do you expect it to take? All right, Mr. Vaughn, we're here today because you have filed a number of different motions, and I want to address those motions with you, give you an opportunity to be heard. So if you want to come to the podium, since you are representing yourself, I will deal with each of those motions. First of all, let me advise you that in April of this year, you sent a notice stating it was to the judge of record, stating that on the 15th day of April 2025, I have some concerns that I wish to speak to you about before I file papers in your court. I'm letting you know this isn't a request for advice. It concerns actions by your staff of the courts and yourself. With the utmost respect, I write this ex parte letter. If we can meet in private, I will. If I can't meet in private, I'll file it publicly and the order will be noticed. I could not speak with you privately because of the rules of conduct for judges. So the first notice or first motion that you have filed has been a request for a criminal record, and states that you're requesting the courts to move the state to furnish the defendant with a copy of prior criminal record per Rule 16 of Discovery and Inspection, Rules of Criminal Procedure. If I understand correctly, you're asking for a copy of your criminal record?
Yes, all them requests, the motion discovery is supposed to provide all that anyway, so that is summing up half the motions. I mistakenly filed them separately.
That's fine.
Some of them.
You're entitled to discovery requests. Here, when you have a lawyer, a lot of times what will happen is the lawyer will be given access to the electronic system that the DA's office has implemented, where all of the discovery information, all of the evidence is loaded into an electronic system that then the defense lawyer can access that defense. Now, you don't have that ability representing yourself. So I'm going to order that all of the evidence in Mr. Vaughn's case needs to be put into written form, hard copies, and he needs to be provided with that.
Judge, the problem with that is going to be that there are videos from his arrest. One of his charges is retaliation for past action. And so there are videos from the officers in the jail at that time. And that's going to be one of the largest problems in providing that to him.
No, sir, that's not a problem. I filed a civil suit years ago. They provided me with the DVD, and it was my issue to deal with after that. And they allowed me to go into the office privately, view my own case, to fight my own case before, so that is not an issue.
Sounds like he's got it solved.
Okay.
You provide him with a DVD or a video on a compact disc. He'll access it as he needs to at the jail.
Okay.
All right, when is this gonna be? Because I've been doing some of this since 2021. I'm tired of coming here looking at y'all. Like, this is going on for a minute. This is getting ridiculous. This is my first, I still ain't got a motion yet.
A motion?
I ain't got a motion yet. All the attorneys I had, all the public defenders I've had, nobody have provided me with nothing yet.
Okay. Well, I'm going to deal with all of that today because you're going to get written discovery. You're going to get a copy of any videos so that you can look at them yourself. How long will it take for him to be allowed? His trial date's in September. How long will it take to get the hard copies of the written discovery? All right, we'll have it within.
Ben, she should have it today.
We'll have it within 10 days. Okay. You have a second motion, which is a motion to remove your counsel. Mr. Spratt was appointed as what is generally referred to as elbow counsel. You want to represent yourself, and I've granted you that opportunity. I've also appointed Mr. Spratt to assist you in representing yourself so that he can, because you don't understand, I assume, the rules of evidence and the rules of criminal procedure fully as if you had been to law school. So having a lawyer who can assist you in making objections to evidence, for example, and things that's the reason that you have elbow counsel. So Mr. Spratt was appointed, and he has tried a number of criminal cases, is very competent as an attorney, and that's the reason. So why do you want to dismiss your elbow counsel or your assistant
For
counsel?
one, the court doesn't respect the fact I'm pro se. They prefer to talk to him instead of to me. And anything should come through me first. He's an assistant. For two, Mr. Spratt, since December, has had a sickness or illness going on, which is on record in Humphreys County Jail, where he never could show up out there. I called 2 or 3 times. I should have had the motion discovery he just handed me.
All right. Well, that's part of life, that people have illnesses and sickness. I am going
Not for a month and a half. I'm sorry, sir. Excuse me, but not for a month and a half. I mean, he ain't able to help me.
Well, I'm of the opinion that Mr. Spratt is able to help you with this because he is only elbow counsel. You're representing yourself. I will order that the discovery and motions that are filed in his court need to be sent directly to Mr. Vaughn rather than a copy to Mr. Spratt directly to Mr. Vaughn so that he gets a copy without having to wait for his co-counsel. No, you just have to mail it to him and he'll receive it. So I'm denying at this time your motion to remove counsel because I think it's important for you to have someone at trial to help you with that. You're going to have access to the discovery directly. You're representing yourself. Mr. Spratt's role is as elbow counsel to assist you in, the trial itself.
Well, what about the fact that he couldn't even come to Waverly? How are you going to get to Decatur?
I'm going to appoint Mr. Spratt. You want to address any of that, Mr. Spratt?
I will, Your Honor. I'm not sure of what illness I had for a long time. I was sick back during the holidays. I did just hand Mr. Vaughn his discovery in case number 2021 CR 462. My understanding is the state wishes to proceed to trial in 2022 CR 336. There is no discovery that's been provided to me electronically for that case. When I did finally feel better and go to see Mr. Vaughn, he had been transported to West Tennessee, and I just simply have not been able to make it down there with my schedule. But he does have the discovery, or the written discovery. I did not give him the electronic discovery today because of reasons which he's now clarified.
Well, I told you that too when we talked on the phone. Me and you done been over that.
Let me hear from Mr. Spratt. This is not a time for you and him to discuss.
I mean, I'd be happy to mail him a DVD of anything electronic for that case that I have. I only have discovery for one case.
He needs the discovery for the case he's going to trial on, so let's make sure that that discovery is provided to him. Ms. Bryson says she can provide it to him next week, so I would order that she provide that by mail to Mr. Vaughn next week, as he wants to have it directly, and then a copy to you, Mr. Spratt. All right. I am denying your motion to discharge Mr. Spratt from being your elbow counsel for the reasons I've stated on the record. Another motion you have filed is a demand for speedy trial. Your trial date is in September, which is the next term of court that I have. It's available. And for that reason, I believe that complies with the request for speedy trial that was filed. It is the first available date that we can put into play according to our rotation of judges and our schedule that we have. That is the first available day. The September date does, in my opinion, comply with your request. Case won't be continued, so we'll need to make sure that it is ready for trial on that day. The remaining motions that you have filed are all motions for discovery, which I think you had mentioned before, and I think we've now addressed that. So he's set for trial on September the 19th, is that correct? That needs to be shown to be first on the docket.
Excuse me, sir.
Docket, so that we'll go to trial. And let me address this. You filed a motion to recuse, notice of recusal or request for the master clerk, and you're asking to recuse or to somehow recuse the clerk of the court, and there is no basis that you have no basis, you have no standing under the law to ask this court to disqualify the clerk of the court. I understand your reasons for why you say that, and I have addressed the problems that you're saying you've had thus far with receiving copies of things, and that's going to be mailed directly to you. The court file will have it reflected that you are to receive all of those as lead counsel in your case, and I am not of the opinion that you have a basis in law or in fact to remove or ask for a recusal of the circuit court clerk. So that motion is denied. In addition to that, you had a motion to recuse the court recorder. And again, I have no idea why you would allege that there is a reason for that, but I don't find any basis for removal or that you have standing to remove the court reporter. She worked for me, and under that basis, I don't find there's any reason.
Well, then me and you have a conflict then, because you was on there doing the same thing they was doing. You want to put this on YouTube and not act a professional? Y'all want to make jokes in here? And then they don't want to file the paperwork? How am I going to get a fair trial here?
You're going to get a fair trial because you're going to be tried according to the law and the facts. And a jury of impartial people who know nothing about your case will make the decision.
So if I want to make an appeal and she ain't recording it, how are we going to do that?
She will be recording it if it is a felony case. There are certain times when the cases are not recorded, or if we're on break, it's not recorded. But
well, we wasn't on break because look, I just walked out the courtroom and I said something after we went on break. You said omitted, and she said, "Well, I ain't got to omit it." She said I wasn't recording no way. So how can I appeal something if y'all taking it out of the record without me being present during the proceedings?
Well, first of all, I don't recall any such thing that
Well,
you're
go back and look at the video.
I'm not required to go back and look at the video, Mr. Vaughn. I'm required to make decisions based upon whether or not you have standing for the motions that you filed. In my opinion, you don't have any standing to ask this court to discharge our court reporter or our clerk. And for that reason, I'm denying those two motions.
Well, recuse yourself because you're not doing it. You're not doing it.
And there's no basis for me to recuse myself.
Is this being recorded?
If you want to file a motion for me to recuse myself, then I will deal with that under Rule 10, and then I will.
I'm familiar with all the rules. Y'all sit me in jail long enough. Best believe I read them.
All right. Anything else?
No, that's all.
All right. Thank you.
Briefly, if I may, when would Mr. Vaughn be transported up for this trial? Because the trial that I
don't
mentioned.
put in 3 motions for that. That ain't get heard either.
I'm just asking for it because the trial that I have in Davidson County that I mentioned in the earlier matter is the first of that week. We do not expect that to be a 5-day trial. But I'm wondering if I'd be able to meet with him to strategize at all for this trial beforehand, other than Thursday, the 18th.
We can order that he be transported earlier if you just tell me when you want. The 17th?
No, I like my cigarettes where I'm at. I don't need his assistance.
Okay. Well, that'd be fine, Your Honor.
That's fine with us.
Yes, sir.
All right. Thank you, Mr. Vaughn. You step back.
Oh, leaving the room.
All right. I believe now that we've dealt with Mr. Fan that.
Okay. Oh my gosh, that guy. He was the best. Thank you very much, Josh, for that suggestion. I'm gonna probably definitely clip this out and post it as a single video after the stream. But I know his face was like, this judge faces a lot, and he has to face some wild people. I think it's the same as Judge Boyd, like, and Judge Fletcher as well. All these judges that are out there and doing YouTube and everything, they just face this wildness. Man, Josh coming in clutch and showing us this, thank you very much. I really do appreciate that. And that was a very spicy way to finish the stream. I think we're gonna leave it here for today. It is a shorter stream, I know, I apologize, but I do some investigations to do for our dear friend Kimbers, and my niece is on the way, so I need to get myself semi ready for that. And then later on, my cousin is gonna stay over with us for the weekend, so I need to get ready for that. And I'm gonna spend some time with Nightbot, with Gardenbot. I not, but you guys have a wonderful Friday. Have a wonderful weekend. A good Memorial Day weekend indeed. I hope you all enjoy it. It's the beginning of the summer, of the hot weather, and we'll be here for it. So have a great evening, afternoon, morning, wherever you are in the world. I'll see you Tuesday, ready for Karen Reed. If not, Maxwell Anderson. We'll see you what happens, but definitely see you there. Have fun. Bye.
And I'm a real-time crime professional.